चा घालो आता आपल्या ह्याच्यामध्ये खडबड राव खडसे किती रोय पाटील आता बंद होते हे बी भाषक कुठून तिकडे गेलं शब्दांना खाल्लं हात घालून
Do it in the chambers. Tomorrow could it? Go page wise. Page wise. No, we're going page wise. What do you want?
Number 12, number 49-55.
Lords, 47, my lords.
1 minute.
Sorry, my lords.
Yes. Wait.
With kind permission 45 million.
2011. Let us see when the matters.
With kind,
7, my lords.
Give you my file. Let us see 2011. Yes.
That's 47.
45
My
million.
lords, that Wakalat should be filed. I have written a letter to the client, my lords, but I'm not able to trace him. Kindly give me 4 weeks time, my lords, in case he
No.
doesn't.
Let us see.
My lords,
Please wait.
I don't have Wakalat, my lords. That's why, my lords.
Especially for non-prosecution, if you don't have wakalat, that is all.
I have sent a letter to him, my lords. 2 weeks,
No,
my
I
lords.
can't wait. It's 2012.
2 weeks, my lords. Finally, 2 weeks, my granted, my lords.
Let us
If I
wait,
do-
please.
If I
Please
don't
wait.
receive, no, lords, if I don't receive the letter, I will definitely file a
I've
memo.
adjourned the matter. I've adjourned the matter on 2 occasions.
That's the letter is, I just received a letter.
No, please wait. Please wait. Let us see what is the matter about. Let us see. ಹೇಳಿ ನಾಯಕ್ರೆ.
45ನೇ ಮೀಟರ್ ನಾಳೆಗೆ ಹಾಕೊಂಡ್ರೆ ಒಂದು ಸ್ವಲ್ಪ
ನೋಡೋಣ ಇರ್ರಿ.
ಇನ್ಕನ್ವೀನಿಯಂಟ್ ಇದೆ.
ನೋಡೋಣ
ಸರಿ.
ಇರ್ರಿ. ಯಾರ ಬರ್ಲಿ. Yes. $70. ಅವ್ರು ಹೇಳಿದಿರಾ?
Seal number 68, my lord.
Yes.
Lord, short account next week, my lord, may kindly be taken.
ಅವ್ರು ಹೇಳಿದಿರಾ?
I did, yeah, he's there, he's there.
All right.
Number 80 to 88.
ನಾಳೆ ಬರ್ಲಿ ತಗೊಳ್ಳಿ ಏನಾಗುತ್ತೆ. Let us see, ma'am. You can't actually move vacating. Please wait. Please wait. ನೀವು ಯಾರಿಗೆ ಲಿಸ್ಟ್ take notice for respondents. List implementing on along with number ಕೊಡ್ತೀರಾ? ಇದ್ರೆ ಕೊಡಿ ಪೋಸ್ಟ್ ಮಾಡಿ. ನೋಟಿಸ್ ಯಾರು ತಗೊಳ್ತಾರೆ? Will take notice. AGA to take notice. Your R3 ಗೆ R3 ತಗೊಳ್ತೀರಾ? AGA to take notice for R1 and R3. Issue notice to R2. ಸರ್ವ್ ಮಾಡ್ಕೊಂಬಂದ್ರೆ ತೆಗಿತೀನಿ. ಅವ್ರು ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ಲ R2. Also permanent report notice. Second plus permanent person. This after 2 weeks on date. This order was passed in 2016. They're coming after 6 years. (2019) 4 years. Ember date ಆಗ್ಬಿಡುತ್ತಲ್ಲ. Take out notice letters. Issue notice then a AGA to take notice for respondents. You ತಗೊಳ್ತೀರಾ notice? AGA to take notice for R1 and R2. Issue notice to R3. 2017 order ಇವಾಗ ಬರ್ತಿದಾರಾ? What is told in Chandra to take notice for respondents. What is the matter about? Notice. Muda Uralva. DP Vivekananda take notice for. Then J to take notice for R1 and R3. Vivekananda take notice for R2. Respondents, Sarah. PG to take notice for R1. ಯಾವತ್ತು ಹಾಕಿದ್ರ? Ms. Brown is entered appeal for R2 and R3. Ms. Gautam is permitted to retire. Behalf of R2 and R3. The group, Allah. Who is presented to the meeting?
Serial number 10, Your Lordship, appear for the petitioner.
Constantly.
Amended writ petition is filed on 11th August 2022, Your Lordship. We have filed already and you have got the endorsement also from the office, Your Lordship.
Petition amendment ಮಾಡಕ್ಕಾಗಲ್ವಾ?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಗ್ರೌಂಡ್ಸ್ ಮತ್ತೆ ಅಡಿಷನಲ್ ಯು ಎಲ್ಲ ಇದಾವೆ, ಹೀಗಾಗಿ ನಾವು ಅಮೆಂಡೆಡ್ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬಿಟ್ಟಿದೀವಿ.
Stated that amendment could not be carried out due to lack of space, but an amended petition is filed. The above amendment of the petition is dispensed.
Appear for the petitioner in serial number 11, my lord.
Your Lordship, in 10 ಅಲ್ಲಿ pleadings ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದಾವೆ. Your Lordship may post the matter for hearing, Your Lordship.
Failing which you shall appear personally and R3.
I am for the petitioner, my lord. Serial number 11, I am for the petitioner.
Extends time.
Serial number 12, I'm for the petitioner, my lord.
No, madam, 13.
My lord, in 12, the matter is this question of law is pending before the division bench, my lord. Therefore, requesting for
Stay with
3
the
weeks.
office objections first.
Please, my lord, I'll do the needful.
Yeah, respondents here. Yeah, refuse model. Private party element review. What's up? What's up now?
My lord, serial number 14. I appear for the petitioner, my lord. My lord, the respondent number 2 was on caveat, and in the last occasion, they submitted that they will appear for all the other respondents.
Since the council for essentially Pradeep Naik submits that he will be appearing for all respondents, payment of process would be unnecessary.
My lord, a small submission in this matter, my lord.
Yes.
But the impugned at annexure M, page number 75, it's withholding my promotion by 1 year, which will end in November this year. I am only requesting for my lords to direct the other side to file objections at the earliest, my lords.
You can within 2 weeks.
Oblige me.
ನೋಡಿದಿರಾ last time as a last chance a week's time is granted ಅಂತ ಹೇಳಿದ್ದೆ. Who's to be present? Who's to do the need? Though it was stated that a week's time was being granted as a last chance to secure instructions. No instructions have been given to the Gunner AG. Left with no other alternative. The fifth respondent is directly personally present the next date of hearing. So if objections are over filed, his presence would not be necessary. Relist on. ಇಲ್ವಾ week's time is beginning. issue emergency notice ಅಂತ ಇದ್ರೆ permitted to take out notice ಅಂತ you pay process it is ರೆಡಿನಾ ನೀವು why two writ petitions? ಒಟ್ಟಿಗಿದೆಯಲ್ಲ ಎರಡು ಇದೆಯನ್ರಿ ನಂಬರ್ ಕೊಡಿ post along with sponsor. ಯಾವ್ದು ಬೇಕು ನಿಮ್ಗೆ ಯಾವತ್ ಬೇಕು ಇಲ್ಲ ಯಾವತ್ ಬೇಕು ನೆಕ್ಸ್ಟ್ ಯಾವತ್ ಬೇಕು ಲಿಸ್ಟ್ ಚೀಟಿಯಲ್ಲಿ ಕೊಡು list date kodu. The respondent should not postpone the matter to the next date of hearing. Party ಯಾರು? ಇಲ್ವಾ? Week term is granted. The correct address and the ಕೊಡಿ ಸಾಕು ಅದೇ address ಹೋಗುತ್ತೆ. Council is also permitted to amend the first title so far as it relates to the address of the second respondent. Which one is that for the next? Sections ಹಾಕಿದ್ದಾರೆ ಈಗ ರೂಲ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ ರೂಲ್ has been issued reinstatement page on what charge were you why were you suspended? ಆಯ್ತಲ್ಲ ಬಿಸಿ ಆಯ್ತಲ್ಲ ಇವಾಗ ಯು ಕ್ಯಾನ್ ರಿವೋಕ್ ದಿಸ್ This order of suspension is passed only in order to diffuse the tension there, isn't it? But can you hold the AWE responsible for a wire being snapped? So then you can also then suspend the MD because he is overall in charge of the entire state, isn't it? You proceed the inquiry, but why do you want to keep under suspension? ಆಯ್ತಲ್ಲ ಒಂದ್ ತಿಂಗಳು ಆಯ್ತಲ್ವಾ ಈಗ ಸಾಕಪ್ಪ punishment is good enough or you want some more time? Second incident same. What is R4? What is the report that you've got? ಅಲ್ಲೇ ಇದ್ರೆ ತಿರ್ಗಾ ಗಲಾಟೆ ಆಗತ್ತೆ ಮೇಡಮ್. Or else I'll pass an order. If you don't pass an order by yourself, I'll pass an order. When do you want? Thursday. ಮಾಡಿಸ್ತೀರಾ? ಮ್ಯಾಟ್ರ್ ಏನು? ಸರ್ AB ನಾ? Which time is granted to do need AGA to take notice for R1. Iವ್ರಿಗೆ US ಗೆ M Srinivas to take notice for R2. What is the next LC? Knock me. Report. Which respondent? Last time I had told. What are the instructions? No, I remember that he said that there's a medical certificate indicating he does not have knock me. Can you? But the medical report of a doctor, private doctor says something else, isn't it? How do you reconcile that? Why can't you reconsider this? Why can't you reconsider this by taking into consideration this particular report? Where is your medical report? Next year. Where is that centimeters mentioned? It only says knock knee. What is the definition of knock knee according to you? Where is it? Page number? You know the page number in this? But this private doctor has given it as 3 centimeters. I'm not a doctor to examine. Who was your medical board? Who examined him? What do they say about the report that he has furnished? No, but have they examined this particular report of M. Ramaya College? When you ask them to look at this and then make their submissions, if they're able to conduct one more examination and see whether this is right or wrong, that could solve the problem. If there is some mistake, this doctor would also be a bit responsible, isn't it? No, but he has given a scan report, isn't it? Now, could that be considered before you come to a conclusion? This is obviously on the basis of physical examination. But if there's some diagnostic report indicating that he does not have this problem, let the doctor consider it and then relist on. Copy ಕೊಟ್ಟಿದ್ರ ಅವ್ರಿಗೆ? ಅವ್ರು ಕೊಡಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ. Relist ಅದು ವಾಪಸ್ ಬೇಕಾಗುತ್ತೆ. edit that process being paid in respect of R4, released after service of notice.
Copies has not been served, my lord, on R1 to R3.
ತಗೊಳ್ಳಿ.
Serial number 24.
ಕಾಪಿನ ಕೊಟ್ಟಿರುವಂತ ಅವ್ರು ಫಸ್ಟ್ ಸರ್ವ್ ಮಾಡಿ ಆಮೇಲೆ ಕಾಪಿ ಕೊಡಿ ಅವ್ರು ಫಸ್ಟ್. Who's R4? What is the order that you're explaining?
Transfer orders, Madam.
Why did you make R4 a party then? ಏನಕ್ಕೆ ಮಾಡ್ರಿ R4 party? Memo is filed seeking for deletion of deletion, delete ಅಂತ ಇದೆ. Deletion of R4. So R4 is accordingly deleted as requested.
Yes, Mayor. I am for the KVA terminal. He has taken the charge on 11/8/2023. Charge is given by the petitioner, Mayor.
Is it a premature transfer?
Yes, Mayor.
Then how do you justify this?
Mayor, for all the, not one Mayor, is for all 27 people, 37 people.
ಎಲ್ಲರದು ಕ್ವಾಶ್ ಮಾಡ್ಬಿಡ್ಲಾ?
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ government has taken a decision and extension was made by the annexure. B may be kindly seen, Mayor. Government has extended the time based on that. Annexure C, Mayor.
When were you transferred earlier? 8/5/2022, not 6/5.
Yes, sir.
ಏನ್ ಮೇಡಮ್? Day after tomorrow. Who's R2 and R3? Acknowledgement ಇದೆಯಾ ಇಲ್ವಾ? You will not go serve on them personally and come. Without their name being shown, how is it that I can't dispose it of? ಯಾರಿಲ್ವಾ HPCL ಯಾರಿಲ್ವಾ? Current confidence are copies of the petition on slow ಅಲ್ಲ HPCL HPCL ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ? ಇಲ್ಲ HPCL ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ? Find out, because I can't dispose it of without notice being served on them. And that is already ordered. You have only have to pay process. Week's time is granted to the need. Application is filed seeking for direction to be issued to the registry to transmit the amount to the tribunal. It is noticed that the registry has already transmitted the amount to the tribunal. In view of the above, the application is unnecessary. ಏನಕ್ಕಿದ್ದಾರೆ ಅವರಿದ್ದಾರ? What is the direction you are seeking for? PMC ತಾನೆ. Yep. Biophysics. ಅರ್ಥ ಮಾಡ್ಲಾ? $99. What is the requirement here?
Yes.
Where is the qualification prescribed here? ಇಷ್ಟು ಜನ ಕೊಟ್ಟಿದ್ದು?
Page 3 members. In 1994, regulation developed
This page number 3 is a part of this 19 regulations. Lecture in biophysics. ಎಲ್ಲಿದೆ ಅದು ಕ್ವಾಲಿಫಿಕೇಶನ್ ಎಲ್ಲಿದೆ ಇದಕ್ಕೆ? ಅದಾದ್ಮೇಲೆ ಬೇರೆ ಚೇಂಜ್ ಆಗೋಯ್ತು.
Next one looks like page 9 members. In 2008.
Where is the complete notification as regards lecture in biophysics? Page number 3. ಇದರದಲ್ಲಿ what is the requirement for lecture in biophysics as on 1999? When were you appointed? Where is that C&R rules prescribing education qualifications? We'll go one by one. 1999, if you had to appoint lecturer in biophysics, what was the education qualification required? Because the last one that you told me indicated, if he has an MSc for all these fields, right up to professor, that was sufficient. It's the one that was furnished on the last occasion. Because for the, as per this page 54, for all the 4 posts, the qualification is identical. My understanding was, if you have an MD in biophysics or an MSc in biophysics, that is good enough to be a professor also. No, the highest post for all. Come to page 54. This is why Katie was asked to give us clarification. There are 3 kinds of qualifications prescribed. There are 2 Rs, MD biophysics / MSc biophysics. That is the first one. So if a person has either an MD biophysics or an MSc biophysics, he can be eligible to be appointed as a assistant professor, reader, and also as a professor. The next one is that is, if he has a medical biochemistry, then he requires a PhD in biophysics. Or ಎಲ್ಲೆಲ್ಲ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ, ಅವೆರಡು ಸಪರೇಟ್ ಕ್ಲಾಸ್ ಮಾಡ್ತಾರೆ. First class is MD biophysics and MSc biophysics. If he has that, that is good enough. In case, PhD in biophysics is if he has a medical biochemistry. Then the word "or" would not have been there. I'm reading it like this. There are 2 R's here. So therefore, the first qualification was MD biophysics / MSc biophysics. So suppose any person has either of these 2 qualifications, he is automatically qualified. Now, that PhD is required only if he has an ND or an MSc in biomedical biochemistry. That is why they use the word "or" here. If a person has, let us say, an MSc in medical biochemistry, then an addition of PhD of biophysics is required. Then no. I'll dispose it of, because MSc biophysics clear agide. Nan prakara it is clear. There are 3 classes. One is a master's. If he has a master's in biophysics, he's through. He does not need anything else. If he does not have a master's in biophysics, if he has a master's in medical biochemistry, then he requires a PhD in biophysics. Then the next is, if he has an MD in biochemistry, then he needs 1 year training in biophysics. Because the intent is, if you are MSc biophysics or no, if he has been appointed as assistant professor or lecturer, now then he is entitled to be considered for promotion to the post of associate professor. The only thing is, he would have to be an assistant professor or lecturer by physics for 5 years. That is the only requirement. I will hold that he holds the prescribed qualification. Your interpretation, according to me, is wrong. Whether you have a teaching subject or not, he is entitled to be promoted. He will continue to be a lecturer. That is. But only one increment is we are paying every year the increment is No, if this is your argument now, that means having appointed him, he has no promotion avenue at all for his entire life.
Even for 100 MBPS, later in the, it was 150, 200.
But what should happen to him? Give him a promotion as per the regulations that was in force when he was appointed. Promote him, that is all, whatever is benefit financially will get, but he will be doing the same job. Whatever work you want to extract from him, you extract, but you have to give him promotion if he is eligible. You will have my order. You will have my order. You will have my order saying that he is eligible. Hello? The word or that is placed are making three distinct categories. One is, like you said, medical biophysics, a master's in medical biophysics, a master's in regular biophysics. This is one category. Now, in case they have a master's in medical biochemistry, then they would require a PhD. No. It says MD biophysics or MSc biophysics is the first category. No, forget about the slash. I'm concentrating on the R for or. The two qualifications before the word or is the prescribed qualification first. The first category is if you either have an MD in biophysics or an MSc in biophysics, you are through. You are qualified. The second is if you have what was the qualification prescribed prior to this? No, this is 2007. What is the first one? Because this was 2007 notification. This. Let us see the 1999 regulations. C&R, what are the education qualifications prescribed in the first first MEQ of the year 1999? Was it the same or was it different? He has produced just the first sheet. He has not given the remaining sheets along with the memo. No, he has not produced. In respect of the post of biophysics, he has not produced that chart indicating the qualifications for all the 4 posts, which should be annexed to this first document. 97. What is this? This is called minimum requirements for 100 MBBS admissions annual regulation. This is for. Then what are you giving? This is not. ಇದೇನಿದು ಈ notification ಕೊಟ್ಟಿರೋದು this is minimum requirements for 100 MBBS admission. So ಅದು ಕಾಲೇಜ್ಗೆ ಏನೇನ್ ಬೇಕು ಅಂತ ಇರೋದು ಇವ್ರ ಕ್ವಾಲಿಫಿಕೇಶನ್ಸ್ ಏನಿದೆ. Looking at the wrong. This minimum qualifications for teachers is separately regulated. The first one was in the year 1997. Correct, Katie? Page 74 is document number 7. Same thing which is produced in the writ petition. So if your argument is correct, even for a medical biophysics, MD biophysics, even then you require a PhD. Again, that will be a wrong argument, because if that's slash or is to be construed separately, then this with goes with the MD biophysics also. You should have categorically said MD biophysics is one separate thing. If you have an MD biophysics, they're enzymatic, you're through. It should have, what you say is correct, it should have been MD biophysics, first category. The second category would have been MSc biophysics or medical biochemistry with PhD. No, slashes and or are different. They distinctly use or to make that segregation. Now you are selectively applying this with whenever you want. Was there any regulation prior to this 97 regulations? Or is it there for the first time? Did it repeal any other earlier regulations? He may be right, Shri Prasad. If you look at this, or is within the bracket. MD biophysics is one thing / MSc bracketal biophysics or medical biochemistry. So the MSc could be either in biophysics or medical biochemistry. If you have this, then you require a PhD. Then the next one is or MD biochemistry, that is medical biochemistry with 1 year. So this or is fundamentally between either if you have a biophysics or a medical biochemistry, then you require a PhD. No, that is for everybody. Where? Yes. Only for associate professor, it is required. Where do you get that? I thought whenever you say MSc, it's always. Like, what is the medical MSc qualification? Let me understand, because my understanding was it was always an MS or an MD. No MSc is given by any medical college. I've not heard of any medical MSc. No, please explain what a medical MSc qualification is according to you. No. This is a master's in science. This is granted only by a non-medical college. A medical college is either grants a master's in surgery or a master's or an MD or an MS. No, on please read this once again. I am directed to state that the council and its regulations on so and so has prescribed that a non-medical candidate having medical MSc qualification in the subject and thereafter 4 years experience as tutor, resident, demonstrator, registrar, the subject can be considered eligible for the post of assistant professor. So he's a non-medical candidate. You tell me what is the medical MSc? Where do you get that? So please explain what a medical MS. Please explain to me what a medical MSc is. Now put it on oath. Let us see. Because I have not come across medical MSc. That is the only thing that is the only thing I am worried about, because he can't be stuck in one post for his entire career. That is why the clarification is given. If he is a non-medical candidate, if he has that medical MSc with him, then if he has worked for 4 years, he is eligible for being considered. Or he can't go further. Assistant professor is the last. Associate professor if wants, then he has to have a PhD. Realist on. What do you want? What are you challenging here? It's X and Z. ಯಾವ್ದ್ರಲ್ಲಿ ಮೆಮೋ ಅಲ್ಲ ಪೇಜ್ ನಂಬರ್
Service condition of the employees 6 months transfer of personnel in terms of these shall be subject to the terms and conditions contained in the act tripartite. The act unless the board regulations that time also 6 say that the service conditions of the employees of the respective
But if that power of the board is extended as per this 6(5), then the board continues to have that power. Then there's a vacuum according to you. So then during that period, nobody can do anything.
the existence of the order given between which committee which are denied upon. And the order is. We have looked at diagram also.
Yes.
And then the order of the appropriate. 85 the act will indicate that all actions that are already taken place under the repeal law, that we need to have done and get the corresponding
No, even despite the, whatever it is, somebody should continue the proceedings. Where is the provision which you rely upon? No, take,
effective date of first draft of elected. Board shall stand beyond. The chairman and the member of the board shall be to have retained it. From the function, duty, the power to get a board. Yes, are notified by the government. Board members do not have the power to exercise the function. Have the function, they have the power. Then the between them, whether they will have or not.
you have the entire because you only produce section 1 to 13 is missing. Starts off with section 13. Let him want to continue till then. Who's to give you the salary? Put a copy, put on. Release one copy of the application be served on the Brijesh Patel. Varadar Badvan.
Seal number 32, Malaj.
Yes.
Malaj, the institute Malaj was respondent number 2 and 3 Malaj were directed to file objections Malaj on 11/8/2023 Malaj. Objections are yet to be filed, please.
ಏನ್ ಮಾಡ್ಬೇಕು?
Great, sir.
ಮೂರು ಇದೆಯಾ ಅಂತ? More week time is going to be. ಹೌದು. Next Monday. What is the matter about? What are you challenging here?
Not eligible towards the we transferred actually ಮೂಲತಃ ಸಹಾಯಕ ಅಭ್ಯರ್ಥಿಗಳು ಸ್ವಂತ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿದೆ ಸಹಾಯಕ ಸಹಾಯಕ ವೇತನ ನಗರದಲ್ಲಿ ಚಿಕ್ಕದಂತೆ ಇಲ್ಲಿ ಖಾಲಿ ಇದೆ ಅಲ್ಲಿ ರೆಗ್ಯುಲರ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಪ್ರಮೋಟರ್ there's no any right to challenge this. So only current duty charge my lord. Recently from as per her own document see.
Then I'll have it at 2:30. Get instructions. You only have to argue. 2:30. Get instructions. Get instructions and get ready by 2:30. Or else I'll dismiss the writ petition right now. Till tomorrow. Tell your senior that they are opposing and therefore judge refused to grant time. You get ready and I'll hear you and pass orders tomorrow. Naikre. Nagendra Naik avare. Unmute yourself. Unmute yourself.
Yes, sir. I am appearing, sir.
Yes.
Here in this matter pertains to payment of pension for employees. It is based on the judgment of one Karnataka High Court here. And subsequently there was a special leave petition against that order. Special leave petition, Supreme Court confirmed the High Court judgment. Thereafter, some implementation took place, but there is a disparity in the date of cutoff date. So challenging that, there is a contempt petition and 2 miscellaneous applications are pending before Supreme Court. It was heard on last 22nd and adjourned to 12th September.
3 weeks, sir. Matter ಏನು? ಅಲ್ವಾ? Rakshita to take notice for respondents 1 and 2. Notice to R3 to R9 deferred for the present. Released illuminating on. Copy ಕೊಡಿ ಅವ್ರಿಗೆ. ರಕ್ಷಿತಾ. Notice.
Serial number 41 here on.
Who do you appear for?
Serial number 41, I am for the petitioner here. I'd
Yes.
like to apologize. I am a patient of test who was not able to appear before your lordship in the previous occasion.
Yes. What is annexure A?
Your Honor.
What is annexure A? Or the Judicial Pay Commission?
Yes, Your Honor. This writ petition is that of annexure A to set aside the enhancement of personal pay which has been denied to the petitioner. The petitioner was appointed to the service in the year 1988, Your Honor. 1992 nalli he was granted personal pay after he underwent small family norms. In this case, Your Honor, the petitioner's wife underwent tubectomy operation and they have undergone family planning as required under the rules. Other ಆಧಾರದ ಮೇಲೆ personal pay na grant ಮಾಡೋದು. After a lapse of few years, Your Honor, the personal pay granted was enhanced from 75 rupees to 150 rupees to 300 rupees to presently about 920 rupees.
Yes.
As of now, the petitioner is retired from service. He is no longer in service. But the last pay that he got, his personal pay was still rupees 75 only. Our only request was kindly enhance it to the existing rate under which his junior officers are drawing the personal pay. Our junior officers, they are drawing 300 rupees or 920 rupees as per the existing rules. Only the petitioner is drawing 75 rupees, which we requested for enhancement, and that has been denied. That is the crux of the issue, Your Honor. There is
No, but if juniors to him are still being paid this personal pay, notwithstanding the revision. How can you deny him that relief? And if they are being paid enhanced personal pay, then consider his case. No. He's aggrieved by this refusal, isn't it? By annexure A. And that has been refused only because of the First National Judicial Pay Commission pay fixation. But what he's saying is other officers are being given this particular personal pay, and it is also being enhanced. Correct, huh?
Yes, Your Honor. Now, one clarification I'll provide, Your Honor. Kindly see para number 10 of the objections filed by the state.
Yes.
It is submitted that the personal pay cannot be given retrospective effect. We are not asking for retrospective effect at all, Your Honor. ನಾವು ಕೇಳ್ತಿರೋದು ಯಾವತ್ತು ರಿವೈಸ್ ಆಯ್ತೋ ಅವತ್ತಿಂದ ಎಷ್ಟು ಕೊಡಬೇಕು ಅಷ್ಟೊಂದು ಕೊಟ್ಬಿಡಿ ಸಾಕು. We are not asking for retrospective back pay of the personal pay.
When was it increased according to you?
Your Honor?
When was it increased, this personal pay?
In 2005, kindly see.
No, you said personal pay of 75 was granted in 1992.
1992.
Then when was it enhanced?
1996 and once again in 2005.
How much was it enhanced? How much was it enhanced to?
To 150 rupees.
Are you sure?
Yes, Your Honor.
Then the next enhancement
was at 300 rupees, which
when?
And presently it is at 920 rupees.
The next 96 ಆಯ್ತು, next ಯಾವಾಗ ಆಯ್ತು?
2005.
ಎಷ್ಟಾಯ್ತು ಅದು?
150 rupees ಆಯ್ತು.
96 150 ಆಯ್ತು ಅಂದ್ರೆ ನೀವು 300
sorry, 300, Your Honor. 300.
Next
it was enhanced that from 2006 onwards it became 920 rupees.
When was that Judicial Pay Commission
1999, I believe.
1796 ಓದಿ ಮೇಡಮ್ annexure A ಒಂದು. What is this 18/12/1999 order that is referred in annexure A? Is a reference to an order in 18/12/1999.
Annexure G, Your Honor. Annexure G.
No, annexure J is 23/9/2003. There's a reference to, come to page number 17.
Yes, Your Honor.
Read from the second ರಾಜ್ಯದ ನ್ಯಾಯಾಂಗ ಅಧಿಕಾರಿಗಳಿಗೆ.
I am not in possession of that proceedings, Your Honor.
And who are the other persons who have got this?
But I am denying on this. Your Honor.
ಬೇರೆ ಯಾರಿಬ್ಬರು ಬಂದಿದೆ ಅಂದ್ರಲ್ಲ ಯಾರಿಗದು?
No, annexure in page number 69. There is another judicial officer who has been drawing this small family norms personal pay at ₹300.
ಎಲ್ಲಿದೆ ಅಲ್ಲಿ ಕಾಣಿಸ್ತಾ ಇಲ್ವಲ್ಲ?
Annexure in your page 69.
ಎಲ್ಲಿದೆ ₹300 ಪರ್ಸನಲ್ ಪೇ? ಸ್ಮಾಲ್ ಫ್ಯಾಮಿಲಿ ನಾರ್ಮ್ಸ್.
Item number 11 SFN anta ide, that is small family norms. She is drawing at ₹300.
ಒಬ್ರೇನಾ?
That is only an illustration, Your Honor.
ಇವಾಗ ಅವರು ಕಿತ್ತಾಕ್ತಾರೆ ಇವಾಗ ನೀವು ಮಾಡಿದ್ರೆ.
But I can't be denied just because they are going to ask for their rights, Your Honor. In fact, this discussion happened before the previous bench as well.
ಇದು ಯಾವ ವರ್ಷದಿದೆ?
2010, Your Honor. Pay scale is 2000.
This is 85.
No.
Where is that 1999? If it has been increased for you to apply that 18/12/1999.
Your Honor, page 57, annexure G. On page number 59, Your Honor, the proceedings orders that
Page
Kindly,
number?
if I read your 59.
59.
58 and 59, Your Honor. ಮೇಲಿನ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಮತ್ತು 2ರಲ್ಲಿ ಓದಲಾಗಿರುವ ಆದೇಶಗಳ ಅನ್ವಯ ದಿನಾಂಕ 1 ಮತ್ತು 85 ಮತ್ತು ನಂತರ ದಿನಾಂಕಗಳಲ್ಲಿ ಕುಟುಂಬ ಕಲ್ಯಾಣ ಯೋಜನೆಯನ್ನು ದಟ್ ಇಸ್ ಸ್ಮಾಲ್ ಫ್ಯಾಮಿಲಿ ನಾರ್ಮ್ಸ್ ಅಳವಡಿಸಿಕೊಂಡ ಸರ್ಕಾರಿ ನೌಕರರ ಪ್ರಕರಣಗಳಲ್ಲಿ ಅಂತಹ ನೌಕರರು ಶಸ್ತ್ರವೈದ್ಯ ಚಿಕಿತ್ಸಾ ದಿನಾಂಕದಂದು ಧಾರಣ ಮಾಡಿದ್ದ ಹುದ್ದೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಾವ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ಒಂದು ವಿಶೇಷ ವೇತನ ಬಡ್ತಿಯನ್ನು ವೈಯಕ್ತಿಕ ವೇತನ ರೂಪದಲ್ಲಿ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆಯೋ ಆ ವೇತನ ಶ್ರೇಣಿಗೆ ಸಂವಾದಿಯಾಗಿ 1999 ಪರಿಷ್ಕೃತ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ಕನಿಷ್ಠ ವಾರ್ಷಿಕ ವೇತನ ಬಡ್ತಿ ದರಕ್ಕೆ ಸಮಾನವಾದ ದರವನ್ನು ಈ ಯೋಜನೆಯ ಮೇರೆಗೆ ನೀಡಲಾಗುವುದು ಎಂದು ವೈಯಕ್ತಿಕ ವೇತನವೆಂದು ಪರಿಷ್ಕರಿಸಿ ಮಂಜೂರು ಮಾಡಲು ಸರ್ಕಾರವು ಆದೇಶಿಸಿದೆ. ಅಂಡರ್ ಪೇ ಸ್ಕೇಲ್ ಯಾವುದು ಮಿನಿಮಮ್ ಇದೆಯೋ ಅದನ್ನು ಕೊಡ್ಲೇಬೇಕು ಅಂತ ಇದೆ ಈ ವ್ಯವಸ್ಥೆ.
The petitioner, former judicial officer, was granted a personal pay as an incentive, was granted Petitioner judicial officer was granted a special increment in the form of personal pay as an incentive granted to state government employees for promoting small family norms as envisaged in the government order dated 1st of October 1985. The special increment granted to him was a sum of rupees 75 as personal pay. The government order did state that this rate of special increment may be granted in the form of personal pay would remain fixed during the entire service and it would not be absorbed in future increases in pay either in the same post or on promotion to the higher post. However, in the year 1996, that is with effect from 1/7/1996, the petitioner got the benefit of the first National Judicial Pay Commission and his pay scales were revised. On 18/12/1999, the government issued an order enhancing the personal pay and made it applicable from 1/12/1999. This order basically altered clause 5 of the GO dated 1st of October 1985, which had mandated that the special increment granted would remain fixed during the entire service. It is the case of the petitioner that he would be entitled to this enhancement of personal pay, and he also contends that this benefit of enhanced personal pay has been extended to other employees, including one Krishna Baburao Patil. Yes, petitioner also produced annexure in the salary slip of the concerned officer, which also indicates that the said officer has been paid small family norms of rupees 300. He therefore contends that he would also be entitled for the same benefit. Learned counsel for the petitioner also submits that this personal pay has since been increased rupees 920 and the petitioner would also be entitled to the said benefit. The state government has rejected this claim on the ground that the petitioner became eligible for the revised pay scales pursuant to the First National Judicial Pay Commission, and there was no order passed, no order or direction passed if in this First Judicial Pay Commission regarding the incentives granted to the government servants who had adopted small family norms, and therefore the petitioner would not be entitled to the said enhancement in personal pay. It is also stated that the petitioner would not be entitled to seek for this enhanced retrospectively, and it has accordingly rejected the claim. If the government had as an incentive to adopt small family norms, granted a special increment in the form of personal pay, the state government would be obliged to abide by its government order. Though the state government had initially stated that the pay, that the special increment granted as personal pay would remain fixed in the entire service by virtue of its government order dated 18/12/1999. The said position was altered and the personal pay was enhanced. Because the National Judicial Pay Commission did not state anything about the special increment granted as personal pay, that would not disincentivize the petitioner from claiming the same. It is to be noted here that the petitioner contends that in respect of similarly placed judicial officer, enhanced personal pay of ₹300 is granted by Annexure A, Annexure N. In my view, having regard to these facts, it would be appropriate to direct the state government to reconsider the matter afresh and grant the petitioner the benefit of an enhanced personal pay in the same manner as has been done in respect of other judicial officers. Writ petition is accordingly, an Indian order is passed, and the writ is accordingly allowed. ಹೇಳಿದ್ರಾ?
From 1994, here, so you see it was listed. It's not valid. Very decision.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ, ಎಲ್ಲಿದೆ ಕ್ಲೈಮ್ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಆನ್ಸರ್ ಮಾಡ್ಲಾ? ಶರತ್ಚಂದ್ರ When was she removed? After 12 years, you wanted to go back to the EAT. DNP ಮಾಡ್ತೀನಿ ನೋಡೋಣ ಬಿಡಿ. Because I don't want to send them back after 12 years. No appearance in the petitioner, let the other order. Dean, the management. What is the order that is passed? What is the order passed? No reinstatement. What is the order of your so-called suspension? ಅವ್ರ ಮೇಲೆ ಲಾಸ್ಟ್ ವರ್ಡ್ ಬನ್ನಿ. ಆದೇಶದವರೆಗೂ ಕಾಲೇಜಿನ ಕೆಲಸದ ಮೇಲೆ ತೆಗೆದುಕೊಳ್ಳಬಾರದು ಹಾಗೂ and if he was under suspension, you would have said that it went into substance allowance. If you are saying ವೇತನ ಬಿಲ್ಗಳನ್ನು ತಯಾರಿಸುವ ಬಾರದೆಂದು ಈ ಮೂಲಕ he continues to be an employee. ನಿಮ್ ಪ್ರಕಾರನು ಅವರು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಏನ ಎನ್ಕ್ವೈರಿ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಿದ್ರು. ಅವರು ಇನ್ನೂ ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ನಿಮ್ಮಷ್ಟು ಈಗ ಪ್ರೊಯಾಕ್ಟಿವ್ ಆಗಿ ನೀವು ಈಗ ಡಿಸ್ಮಿಸ್. If you say that you will not pay him the bills, you will not submit the bills for his salary, it is a termination. Again, ಏನ್ ಮಾಡಿದ್ದಾರೆ ಇವಾಗ? Have you reinstated him? Reinstate ಮಾಡಿದ್ದೀರಾ? ಎಷ್ಟಿದೆ ಬ್ಯಾಕ್ ಪೇಜಸ್ ನಿಮ್ ಪ್ರಕಾರ? ಇನ್ನು ಎಷ್ಟು ಕೊಡೋದಿದೆ ಬಾಕಿ? For how many months were you out of service? How many months were you out of service? When was this order passed? The next area ಯಾವಾಗ ಮಾಡಿದ್ರು? 6 years. ಎಷ್ಟು ಬರುತ್ತೆ ಅಮೌಂಟ್ ಇವಾಗ? ಎಷ್ಟಾಗುತ್ತೆ ಅಮೌಂಟ್? What is the amount that is paid to you? ಏನ್ ಬೇರೆ ಏನಿಲ್ಲ ಅಲ್ವಾ? ಅಷ್ಟೇ ಅಲ್ಲ. I will also hold that it is a dismissal. Alright, when he made this petition, did you say that you'll pay him subsistence allowance? Did you pay him subsistence allowance from 2006? You did not take him back. Did you pay him the subsistence allowance during this alleged ಅವರಂತರ ಶಂಕುಸ್ವಾಗದ ಇರ್ತೀನಿ ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡಲ್ಲ, ಸಸ್ಪೆಂಡ್ So, admittedly, the department did not find anything against him. No, because Annexure A that you relied upon basically state ಅದರ ಬಗ್ಗೆ ಕಾಲೇಜು ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಜಂಟಿ ನಿರ್ದೇಶಕರು ವಿಚಾರಣೆ ನಡೆಸಿದ್ದು ತೀರ್ಮಾನ ಇದುವರೆಗೂ ಬಾರದೇ ಇರುವುದರಿಂದ ಹಾಗೂ ನಾವು ಕಾಲೇಜ್ ಶಿಕ್ಷಣ ಇಲಾಖೆಯನ್ನು ಮಾನ್ಯ ಆಯುಕ್ತರವರೆಗೆ ಈ ವಿಷಯದ ಬಗ್ಗೆ ಪತ್ರ ಬರೆದಿದ್ದು ಅವರಿಂದ ಸೂಕ್ತ ಆದೇಶ ನಿರೀಕ್ಷೆಯಲ್ಲಿ ಇರುವ ಕಾರಣ. What is the result of this? ಇಡೀ ಆಯ್ತು, ಸಾಕಷ್ಟು ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರಾ? No, I'm only concerned with your order. This order was subject to a challenge. You said the inquiry was had been conducted. You are awaiting the inquiry report from the department. And in that, ಅದು ನಿಮ್ಮನ್ನ ಕೇಳ್ಬಿಟ್ಟು ಡ್ರಾಫ್ಟ್ ಮಾಡಿದ್ರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ. ಬಟ್ರನ್ ಕೇಳ್ಬಿಟ್ಟು ಡ್ರಾಫ್ಟ್ ಮಾಡಿದ್ರೆ ಚೆನ್ನಾಗಿರೋದು. ಅಲ್ವಾ? On 15th of February 2006, an order was passed. Annexure A was challenged, correct? January 13th. Where is that order? You produce that order. On 17th of January 2006, an order was passed by the petitioner institution in the following terms. As could be seen from the said order, the institution took up the contention that the respondent never, that the first respondent should not be taken back to duty since an inquiry was being conducted by the joint director. This order was challenged before the Education Appellate Tribunal. Before the tribunal, the management took up the stand the management admitted the issuance of the communication dated 17/1/2006. They stated that the behavior of the petitioner or the first respondent with the girl students of the college was not congenial, and there were many complaints against his misbehavior. It was also alleged that he was given to vices and was behaving rudely with the public and also the girl students of the college. And as a result of this, the management met on 30th of November 2005 and passed a resolution, the request to the joint director to take action against him, and also addressed a letter in that regard on 2/12/2005. It was stated that thereafter, the first respondent had absented himself unauthorizedly from 9/12/2005 and did not attend the classes. Next, it was alleged that the joint director visited the college on the 6th and 7th of January 2006 and conducted an inquiry. And since the first respondent was absent continuously, the secretary of the institution had decided to keep him under suspension and directed the principal not to take him back on duty by the communication dated 13/1/2006. And accordingly, a letter was, and accordingly, the aforementioned letter dated 17/1/2006 was communicated to the petitioner. It was contended that there was no order passed by the management removing the first respondent from the post of lecturer, and as such, the appeal was itself not maintainable. The tribunal, however, disagreed with the contention of the management and came to the conclusion that the petitioner had indeed been terminated. Paragraph, you said 26, no? The tribunal has made the following observations. Paragraph 26 has recorded the following finding in its order. Having come to the conclusion that the petitioner had been dismissed from service without inquiry, the tribunal has proceeded to pass the impugned order by which it allowed the appeal and directed and set aside the communication dated 17/1/2006 and directed the management to reinstate the first respondent and pay him all the salary and also consultant benefits from 17/1/2006. Being aggrieved by this order, the management is before this court by way of this writ petition. Senate counsel appearing for the management Shri Bhatt contends that there was no order of dismissal as such, and the order passed by management was essentially an order of suspension. He places reliance on Annexure A to contend that the management had only suspended the petitioner and therefore the appeal filed against such an order of suspension was not maintainable. The issuance of the order dated 17/1/2006, which is extracted above, is not in dispute. The terms of the said letter makes it categorically clear that there was a clear direction by the management not to take the petitioner, first respondent back to duty. And this has also been communicated to the first respondent through the communication dated 17/1/2006. Since a positive direction was issued by the management directing that the first respondent to be not to be taken to duty, the tribunal was absolutely justified in coming to the conclusion that there was indeed an order of termination. So the tribunal has also noticed that even according to the joint director, no inquiry had been conducted against the petitioner, and therefore such a direction to the principal not to take the first respondent on duty clearly amounted to an illegal termination. In my view, the reasoning of the tribunal in holding that the petitioner was illegally terminated without conducting any inquiry, and the first respondent is therefore entitled to be reinstated with all benefits, cannot be found faulted. I find no reason to deny this petition. The petition is therefore dismissed. File an execution. I'm dismissing the petition. Go take, do whatever you want. You take this back afterwards.
Please, my lord. Video illa swami adrinda. So piano video problem agide. But however, I'll address the argument, my lord. In this case, my lord, he was a constable, my lord. More than 25 years service in the same department. Subsequently, my lord, some Sabulal and another CJ Ramappa were involved in
2011 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, 2006 ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಹೌದು,
5 ವರ್ಷ
ನಂತರ ಅಂದ್ರೆ ಸ್ವಾಮಿ. What happened in this case, my lord? Because I am facing a criminal trial and criminal.
ನಿಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಕೆಲಸ ಮಾಡಕ್ಕೆ ಅಂತ?
ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ ಸ್ವಾಮಿ, ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ. Because I am neither involved nor I was on duty as on the date of incident, my lord.
An incident,
Incident to 1,50,000 rupees was taken from the vault of 500 rupees notes, my lord, by the Sabulal, Karim Saab, and others, other CJ Ramappa who are on the duties, my lord. He was not on the duty on that day, my lord. Subsequently, my lord, after lapse of 15 days, my lord, some amount has been deposited in the bank account of my father-in-law. That has been taken into consideration through the statement of the accused. And I was made involved. 50,000, my lord.
ಬೇಡ ಬಿಡಿ ನಾಯಕ್ರೆ.
ಅಲ್ಲ, at least ಈಗ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ, ರೀಇನ್ಸ್ಟೇಟ್ ಅಂತೂ ಇಲ್ಲ. At least
ಏನು
ಸರ್ವಿಸ್
ಬೇಡ ಬಿಡಿ.
ಬೆನಿಫಿಟ್ ಆದ್ರು. ಅಲ್ಲ, more than 30 years he has rendered service, my lord.
ಇದು ಕೇಸ್ ಆಫ್ ಫೆನ್ಸ್ ಈಟಿಂಗ್ ದ ಕ್ರಾಪ್, ಇಂಥವ್ರಿಗೆ ಬೆನಿಫಿಟ್ ಕೊಟ್ರೆ ಹೇಗೆ ನಮ್ ಕೆಟ್ಟ ಹೆಸರು ಬರುತ್ತೆ.
ಅಲ್ಲ, ನಮಗ್ ಬೇಡ ಸ್ವಾಮಿ, at least ಮಕ್ಕಳಿಗೆ, ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ.
ಬೇಡ ಅಲ್ಲ, ದಟ್ ಇಸ್ ರಿವಾರ್ಡಿಂಗ್ ಹಿಮ್ ತಾನೆ, ಅವ್ರು ಮಾಡಿದ ತಪ್ಪನ್ನು ಕ್ಷಮೆ ಮಾಡ್ದಂಗ ಆಗುತ್ತಾನೆ.
ಅಲ್ಲ, ನಾನಂತೂ ಇಲ್ಲಲ್ಲ,
If he was associated with 3 persons who had removed money from the vault.
But they have taken into service, my lord. They have reinstated into service.
ಹೌದಾ?
ಹೌದು, ರಾಮಪ್ಪ was reinstated. Sabulal was reinstated into suspend.
ಹೆಂಗ್ ಹೇಳ್ತೀರಾ ಅವ್ರು ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡಿದ್ರು ಅಂತ?
ನಾನು ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ, ನನ್ನ ರಿಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ. Because records are showing, my lord, they are suspended from during the course of inquiry, my lord, immediately relieving the suspension, and they have taken for service, my lord.
ಎಲ್ಲಿ ಹೇಳಿದಾರ?
ಒಂದೇ
ಡಿಲೇ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಬಿಡಿ.
ಡಿಲೇ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಕ್ಕಿಂತ
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಏನಾಯ್ತು? ಅಕ್ವಿಟ್ ಆದ್ರ?
ಅಕ್ವಿಟ್ ಆದ್ರೆ, ಎಲ್ಲರೂ ಅಕ್ವಿಟ್ ಆದ್ರು. That is also order I have enclosed, my lord.
So, but is it a fact that the other two people have been reinstated? ಎಲ್ಲಿ ಹೇಳಿದಿರ? Where have you said that others have been reinstated?
Please, my lord.
ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆ ನಾಯಕರೇ. ಹಲೋ ನಾಯಕರೇ.
ಇದೆ ಸ್ವಾಮಿ, ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡಿದ್ದಿದೆ.
ಎಲ್ಲಿ ಹೇಳಿದಿರ?
ಒಂದೇ ನಿಮಿಷ.
ಗಡ್ಡ ಯಾರ? Where is he admitted? ಡಿಪಾಸಿಟ್ ಅವ್ರ ಮಾಮ ಮಾಡಿದ್ರು, ಬಟ್ ಮಾವ ಮಾಡಿದ್ರು ಅಂತ.
ಹೌದು, ಮಾವನ ಅಕೌಂಟ್ಗೆ.
ಅಲ್ಲ, ನಿಮ್ಮ ಅಕೌಂಟ್ಗೆ ಮಾಡಿದ್ರೆ ನಿಮ್ ಮಾವ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ತೀರಾ? ಏನ್ ಡಿಲೇ ಮೇಲೆ ವಜಾ ಮಾಡ್ಬಿಡ್ಲ ನಾಯಕ್ರೆ?
ಇಲ್ಲೇ ಮೇಲೆ ಮಾಡೋದು ಒಂದ್ ಸ್ವಲ್ಪ ಬೆನಿಫಿಟ್ ಏನಾರು ಕೊಡ್ಲಿ ಸ್ವಾಮಿ.
ಇಲ್ಲ ಇಲ್ಲ, ಈ ತರದ್ ಬೇಡ ಬಿಡಿ, ನಾವ್ ಬೇರೆ ಕೇಸ್ ನೋಡೋಣ.
ಅಲ್ಲ ಏನ್ 3 ಜನ 25-30 ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿ
ಏನ್ ಮಾಡೋದು? ಈ ತರ ಕೆಲ್ಸಕ್ಕೆ ರಿವಾರ್ಡ್ ಕೊಟ್ಟಂಗ ಆಗತ್ತಲ್ವಾ?
ಅಲ್ಲ ನಾನ್ ಇಲ್ವೇ ಇಲ್ಲಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಇನ್ವಾಲ್ವ್ಮೆಂಟೇ ಇಲ್ಲ ನನ್.
The petitioner was working as a constable in the CASF unit. The petitioner along with joint inquiry aita, petitioner along with the 2 other constables were given with the charge sheet. Were served with the charge sheet containing the following charges on a charge, lecture 8. As could be seen from the charge sheet, the constables had planned to remove currency unauthorizedly from the main vault of then BRB and MPL and then BRB and MPL Mysore. And the charge against the petitioner was that despite possessing knowledge about the unauthorized removal of rupees 50 lakhs by Constable Sabulal, he had failed to inform the superiors, and that he had also shared the money to the tune of rupees 1.5 lakhs. The petitioner was also charged with leaving the campus without any permission from the competent authority and having gone to KRPT, which was about 45 kilometers from the unit headquarters. It was also alleged that the petitioner had deposited a sum of rupees 50,000 with the State Bank of Mysore, KRPT branch, under a reinvestment deposit in his name, but had failed to intimate the said transaction to the head office within 30 days as required under Rule 18 of the CCS bracket conduct rules. The petitioner participated in the inquiry, and the inquiry officer, on consideration of the matter, materials produced before him, proceeded to hold that the charges against the petitioner and the other constables had been proved, and a penalty of dismissal from service was imposed on the petitioner. This order was passed on the 14th of August 2006. As against this order, an appeal was preferred, and the appellate authority, by its order dated 20th of November 2006, dismissed the appeal. This petition has been filed. Review yavaga? There. Next year. He has not produced it.
Appellate order, my lord, I have placed. Page number 31, my lord.
Page number
31, my lord.
Which paragraph? Really, which paragraph?
Fourth para, my lord.
As against this order of dismissal of the appellate authority, the petitioner appears to have prepared a revision on 12/2/2007, and the said revision was also dismissed by the revision authority on 29/6/2007. However, reasons best known to the petitioner, this order of dismissal of his revision petition is neither stated nor has it been impugned in this writ petition. Learned counsel for the petitioner submits that the petitioner and the other constables were acquitted, and therefore the orders passed by the department authorities cannot be sustained. In my view, this writ petition is liable to be dismissed both on the ground of delay as well as on the ground that there is no merit in the writ petition. The order as stated above, the order of dismissal was, as stated above, was passed on 14th of August 2006, and the order of the appellate authority was passed on 20th of November 2006. The revision, according to the objections filed by the respondents, was dismissed on swans. For 4 years thereafter, for a period of 5 years after the dismissal of the appeal, the present writ petition has been preferred. There is absolutely no acceptable cause indicated in the writ petition which justifies the interference under Article 226 of the writ petition. That apart, in regard to the fact that the petitioner was found guilty of conniving with constables to remove some rupees 50 lakhs from the vault, coupled with the fact that the petitioner deposited some rupees 50,000 at around the same time and failed to inform the employers, is by itself sufficient to hold that the charges leveled against the petitioner are serious in nature, and the orders passed by the disciplinary authority, the appellate authority, the revision authority, cannot be interfered with. It is settled law that mere acquittal in a criminal proceeding could not exonerate an employee of all wrongdoing unless the charges against him are also held not proved in the department inquiry. So in instant case, the department indicate that the material produced clearly indicated wrongdoing on the part of the petitioner who was a constable. So since there is a serious charge of committing theft by the constable who was supposed to guard the money, I find no reason to interfere. And this is according to this.
Please.
We are again. In matter and you will pass or not. Pass or. ಯಾವುದು serial number? Is an extra G. Extra G channel ಮಾಡ್ತಾರ. Jumadaya. The counsel for the respondent, the memo, view of the said memo. The requisition is dismissed as when become in practice. Next year. Yes. This on Annexure J was only to reconsider the appeal. You have been heard in the matter. If you are guilty of taking money and utilizing it for your own purpose, can there be any sympathy shown to you? Bank money is your money, my money. If the official takes money and uses it for himself, when did you repay the amount? What is that office, sir? Number? What was the substance paid by you? Paid to you? So if this order ultimately, the order of dismissal also states that the period of suspension should not be treated as on duty, will not be entitled for the salary also. What is the amount of substance that you got? It will be 50% only, isn't it? It will be increased to 75%, I'm sure. For a removal of service with which will not be a disqualification. ಕೊಡದಿದೆಯಾ ಅವ್ರಿಗೆ ಕಾಸು ಕೊಡದಿದೆಯಾ ಏನಾರು? Give a representation. The petitioner is challenging an order by which he was removed from service or stating that it would not be disqualification for his future employment. This order of the disciplinary authority has also been affirmed in appeal. Next, the charges leveled against the petitioner was that he had taken a loan. He was under an obligation to one Krishna Gowda to repay some rupees 50,000, 75,000, and that by itself was a misconduct. It was also alleged that while he was working as the Bandiwala branch as an officer, he had temporarily misappropriated some rupees 79,500 by withdrawing cash as being required for the Bandiwala branch, and had utilized the said amount for repaying the loan taken by him from K. Krishna Gowda, and he had thereby institutionalized the bank's fund and acted in a manner detrimental to the interest of the bank. The petitioner did not dispute this allegation of withdrawing the sum of rupees 75,000, 17,500. The inquiry officer, the disciplinary authority, after considering the entire matter, proceeded to impose a punishment of removal from service, which would not amount to a disqualification for future employment. After holding both the charges had been proved, the appellate authority, after considering the contentions put forth by the appellant, by the petitioner, affirmed the findings of the disciplinary authority and found no reason to interfere with the findings recorded by the appellate authority and also by the disciplinary authority, and also the punishment imposed on the petitioner. In my view, having regard to the fact that the petitioner was found guilty of withdrawing money from another branch, contending that it was required for Bandiwala branch, and utilizing the said amount to repay his debts, warrants an order of removal from service, especially when these charges were not disputed by the petitioner. I find no reasons to interfere with the order passed by the respondents, and the petition is therefore dismissed. So the counsel, the petitioner submits that he would be entitled to certain service benefits notwithstanding his removal from service. So if the petitioner is entitled for any such service benefits under the regulations, the respondent shall complete the same and pay the said sum to the petitioner. Subject to the above, the petition is dismissed. Challenging annexure E, na? E and P. What is annexure E? In charges ಏನಿತ್ತು? ಎಷ್ಟು ದಿನ? Where's the order in appeal? Next sir. Four years you have not prepared any appeal. ಏನಾಗಿತ್ತು? What was the charge against him? For how many days?
He died on 5/3/2020.
No, the charge sheet file. For 5 years, you removed from service for 5 months. That was not the charge of previous unauthorized absence. Next year. Yes, the one only 3 of yes. ಅಭಿಯಂತರು ಶಿವಮೊಗ್ಗ ಇವರ ಆದೇಶದ ತಿಳಿಕೆ ಬರೆದುಕೊಟ್ಟ ನಂತರವೂ ನೀವು ಗೈರುಹಾಜರಾಗಿರಿ. What is the second charge?
ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ ನೀಡಬೇಕಾದ ಅಂಕಿಅಂಶಗಳನ್ನು ಕಳುಹಿಸಲಾಗಬೇಕು ಹಾಗೂ ವಿಭಾಗದ ವಿಳಂಬವಾಗುತ್ತದೆ. ಈ ನಿಷ್ಠೆಯಿಂದ ಕರ್ತವ್ಯಗಳನ್ನು ಮಾಡುತ್ತೇವೆ ಎಂದು ಮುಂದೆ ನೀತಿ ಅತಿ ಮಾಡುವ
For discharge. Dismissal for discharge is disproportionate, isn't it?
It was ordered on 2004. When he was very much alive in 2008. 24 to 2008, he got admitted to hospital. And 5 to 2008, he died. For 4 years, he was alive, he didn't record any appeal. Then he was actually in 15/11/2011. His highest filed appeal is
By the LRs. It was neat alone, Bakidoro. Compulsory retirement ಮಾಡಿ at least pensioner ಬರುತ್ತೆ ಅವ್ರಿಗೆ. How many years of service did you render?
Right, service. And you have to balance it immediate need. 2004 ಅಲ್ಲಿ ಅವರು order ಆಗಿದೆ. 2002 ಅಲ್ಲಿ remain ಆಗಿದೆ. ಆಮೇಲೆ there is no in one in the land
But a combined amendment, but at least let her get some pension. Convert this into an order of compulsory retirement. Why should she lose something for her husband's social service? Can only consider compulsory retirement. Day after tomorrow. Release.
Number 50. BC Prabhakar.
Mr. Ena. What is the order to return annexure E? Marks ಕಮ್ಮಿ ಬಂದಿತ್ತು ಅಂತಾರೆ. Marks page 30. Amongst the promotees, you got the lowest ಅಂತ ಅಂತಾರೆ. ಈಗೇನು ಕೊಡಕ್ಕಾಗುತ್ತೆ ಅವ್ರ ಕೈಯಲ್ಲಿ ಕಂಪನಿ ಇದೆಯಾ? ಬೇರೆಯವ್ರಿಗೆ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅವರು. Page. Application memo na. ಹೆಸರೇನು? 29th. ಕಟ್ ಆಫ್ ಮಾರ್ಕ್ಸ್ 70 ಅಂತಾನೆ ಹೇಳ್ತಾರೆ ಅವರು. ಇಲ್ಲ ನಿಮ್ ಮಾರ್ಕ್ಸ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ನಿಮ್ 62 ಬಂದಿದೆಯಲ್ಲ ಅದನ್ನೇ ಹೇಳೋದು ಅವರು. ಅವ್ರು ಹೇಳಿದ ಬೇರೆಯವ್ರಿಗೆ 70 ಬಂದ್ರೆ ನಿಮ್ಗೂ ಕೊಟ್ರು, ಅವರು 70 ಬರ್ಲಿಲ್ಲ ನಿಮ್ಗೆ. ಎಲ್ಲಿ ಓದ್ತಿದ್ರ? What is the eligibility criteria? Eligibility period? ಅದೆಲ್ಲಿದೆ? ಫ್ರಮ್ ಏಜ್ ಗ್ರೂಪ್ 6 ಇಂದ ನೀವು ಪೋಸ್ಟ್ ಆಫೀಸರ್ ಗ್ರೇಡ್ 2 ಕೇಳ್ತೀರಲ್ವಾ? ಎಲ್ಲಿದೆ ಅದಕ್ಕೆ ಎಲಿಜಿಬಿಲಿಟಿ ಕಂಡೀಷನ್ಸ್? Well point. ಇಲ್ಲ ಟೆಸ್ಟ್ there should be a test and interview ಅಂತ ಹೇಳ್ತಾರೆ. ಇದ್ರ ಪ್ರಕಾರ ಹೋದ್ರೆ 12.1.3 ಅಂತ ಹೇಳ್ತೀರ ನೀವು. ಮಿನಿಮಮ್ ಮಾರ್ಕ್ಸ್ ಇರ್ಬೇಕು ಫಾರ್ ಪಾಸ್ ಅಂಡ್ ರಿಟರ್ನ್ ಟೆಸ್ಟ್ 30 ಇರಬೇಕು. ನಿಮ್ಗೆ 40 ಬಂದಿದೆ. ಇಂಟರ್ವ್ಯೂ ಅಲ್ಲಿ 30 ಹೇಳಿದ್ದಾರೆ, ನಿಮ್ಗಲ್ಲಿ 16 ಬಂದಿದೆ. You won't be eligible ಅಲ್ವಾ? Minimum marks for pass an interview, but the others also are not 30. ಬರ್ತಾರ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರೇ? 2:30 will continue. 2:30. ಇಟ್ಟು ನೀವ್ ಯಾರಿಗೆ ಅವ್ರಿಗೆ ಹೇಳಿದಾರಾ? ಲಿಸ್ಟ್ ನೋಡ್ಯಾರ ನೀವಿದಿರಲ್ಲ ಸಾಕು. I'll grant you time to file ವಕಾಲತ್. ಬನ್ನಿ ಆಮೇಲೆ ಮಾತಾಡೋದು. ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅವ್ರು ಬೇಕಾ? ಏನಾಗಿದೆ? ಮುಗ್ಸೋಣ ಬನ್ನಿ, ಇದಾಗಲ್ಲ ಇದು. ಮುಗ್ಸೋಣ ಬನ್ನಿ, ನೋಡೋಣ ಮುಗ್ಸೋಣ, ಸುಮ್ಮನೆ ಯಾಕೆ ನೆಕ್ಸ್ಟ್ ಏನ್ ಬೇಕು? Right.
Kalburgi bench matters.
My lordship, a week time, my lordship. Settlement talks are going on, my lordship.
ಕಲಬುರಗಿ ತಾನೆ?
Kalburgi, my lordship.
Yes, my lord. I am appearing for the appellants in this matter. We have signed the compromise and we have passed it over to the respondents. It seems there is an issue inter se among the respondents. So,
ಯಾವತ್ ಬೇಕು? ಯಾವತ್ ತಕೊಳ್ಳಿ?
ಅವ್ರು ಯಾವಾಗ
Next week, my lordship.
ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ರೆ ಅಷ್ಟೇ ತಾನೇ ಇದೆ. Where is the first order? There is some order passed by the KAT.
Takes an account of an election. That is a part of it. Yeah, we are the respondents.
He was placed in this, he was posted in this place earlier. But it appears that he was posted due to elections. You are also ಅದೇ ಹೇಳ್ತಾರೆ ಆರ್ಡರ್ ಅಲ್ಲಿ KT. Subsequently, by order dated 24/3/2023, Manjunath is posted to Belur. That order is also issued due to elections. Take notice. And we get to take notice for R1, R2, and R3. Who was appearing for that lady in the KT? TV Vijay Simha Reddy. Yes, Jambal was appearing for the third response of the Karnataka Academy. To take notice for R3. Till the next date of hearing, annexed variation on to the article. Here, George Lazarus.
Appear for the petitioner in this case, my lord.
Objections ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
Next week ಹಾಕೊಳ್ತೀನಿ, ಫೈಲ್ ಮಾಡ್ತಿದ್ದಾರೆ objections.
ಆಯ್ತು ಸರ್.
What is the problem?
Date may be fixed, my lord.
What is the problem for settling the pension? Temporary service, released on so and so. Then objection should be filed. The registration.
Oblige, my.
I'm sorry, my lord. I'm extremely sorry. My lord, this is a case where the retired petitioner retired in the year 2012. He retired in the year 2012. He was aspiring for promotion from wage grade 6 to officer grade PS grade 1. Your lordship, kindly see the prayer in page 13. 13B. Issue a writ of mandamus or any other appropriate order or direction directing the respondent to consider the case of the petitioner for promotion to the officer grade PS2 from the present wage grade 6 with effect from the date on which he was eligible for promotion from the year 2004-5 to 2007. My lord, my respectful submissions to you. At the outset, the consideration would not arise at this stage since he has already retired in the year 2012. My second submission, my lord. Kindly see the order of this honorable court at Annexure C, page 24.
Yes.
Page 24. Order. Petitioner is said to be working under the respondent having been appointed way back during 1985 as Miller Grade 2. Thereafter, he has been promoted from time to time. According to the petitioner, he has been working for more than 20 years, and there is also a promotion policy. And as per policy, this case could have been considered for promotion to the post of officer Grade 2 from 2004 itself. According to the petitioner, he is eligible for promotion to the cadre of officer PS Grade 2 to WS1. Further, during 2007, he has attended the written test to consider his case for promotion to the post of officer Grade 2. But when the petitioner approached third respondent, he was issued with an endorsement that promotions have been kept in abeyance. Agreed that petitioner is before this honorable court. According to the petitioner's counsel, other persons have been considered for promotion during 2009-10, and the petitioner's case has been isolated. Accordingly, he has sought for quashing endorsement dated 10/3/2007 and for a direction to consider his case for court. Per contra, counsel representing the respondent submitted the unit is a sick unit and it has been referred to BAF for seeking financial assistance as per the scheme. Till the respondent union is regenerated, there is no scope for promotion and the decision would be reviewed at a later stage. Petition is disposed of by quashing the impugned endorsement. However, it is for the respondent to consider the case of the petitioner according to law. In the event the case of other persons working under them is or has been considered for promotion. Further, since it is issued, it is stated petitioner is superannuating during the year 2012. It is for the respondent to take a decision within 3 months. Well, this is the direction given. And my lord,
Yes.
this is the direction given. This is the direction given. My lord, I have considered, pursuant to the direction given by this honorable court, I have considered, I have issued endorsement at Annexure E, page 28. Kindly, your lordship may kindly come to page 29, para 4.
Yes.
Para 4. After hearing both the sides, the honorable court disposed of the petition with the following direction, the direction which I have just now read. Now, pursuant to the above direction given by the Honorable High Court of Karnataka, the case of Sri Linga Shetty has been re-examined. It is observed from the record that as stated above, promotions from the level wage 6 to officers grade PS2 are still kept in abeyance for the aforesaid reasons. However, while notice dated 10/7/2008, applications were invited from the permanent eligible employees of the company for officer grade 2, assistant engineers for junior officers grade. The qualifications prescribed for the said post is indicated as hereunder. You had applied against the said notification. You were called for written test and oral interview. The selection committee had selected 28 candidates against the said notification, and all the 28 were appointed as officers grade PS grade 2. The cutoff marks for the selection was 70 marks. You were not selected against the internal recruitment since you had secured 62 marks, which is far below the cutoff marks prescribed by the selection committee. In your representation, you have indicated that the names of 28 personal employees contending that they have been promoted to PS grade 2 to 3 and PS 3 to 4. The cases cited by you are not comparable to your case. All 28 cases, even according to you, were promoted from PS2 to PS3 and PS3 to PS4. You have not cited the cases where promotion has been made from wage grade 6 to supervisory officer grade 2. The candidates cited by you in your representation stand entirely on a different footing since the grades are different and they would come under the promotion policy of the company. No, this is the factual portion of the case.
Promotional policy of your company?
My lord?
Where is the promotional policy? What is the requirement for promotion of a person working in this WG6? What is the
promotion? That is a worker grade. But all the promotions were kept in abeyance because of
but you have granted promotions to 28 people. What is
no,
the
totally against internal notification? He had also appeared.
Correct, but what is
the petitioner has also appeared? The petitioners had also appeared. Cutoff marks was 70, whereas he has secured 62.
Under the rules, is it permissible for you to have a written test and cutoff marks? What is the modus prescribed for promotion?
My lord, that is the internal notification had been issued.
No, because Lord Counsel, the petitioner has submitted promotional policy which says minimum marks if he secures 30 and he passes in the interview, that's the end of the matter.
My lord, that is against the promotion policy. This is against the internal promotion policy. All promotions were kept in abeyance so long as he was on the rolls. We are not given any promotion. That is my case, because it was before BIFR.
If this post is reserved for promotion, how can you embark upon a test?
My lord, internal notification, there is a provision, my lord. He had appeared.
Where is the provision? Where is the provision? No, where is the provision?
I will have to collect all those details, my lord. This is after year 2012. I will collect all those details, my lord.
Because the council is relying upon this policy which says that vacancy is of no concern. If he becomes eligible, you have to promote him. That is all.
My lord, that is not automatic, my lord. I have not given promotion to any person. That is my case.
But they have not come to the court. He is relying upon the promotion policy of 27/10/89. He has furnished a copy.
Well, this may be taken up next week. I'll get all the details.
That this was not been considered in accordance with this.
ಬೇಡ ಸ್ವಾಮಿ ಬೇಡ. ಇವಾಗ 12 years ಆಗಿದೆ ರಿಟೈರ್ ಆಗಿ. ಇವಾಗ ತಿರ್ಗಾ ಕನ್ಸಿಡರೇಷನ್ ಪ್ರಶ್ನೆ ಬೇಡ ಸ್ವಾಮಿ.
ಇಲ್ಲ, consider in accordance with this policy. I specifically state that vacancy the prashna baralla anta. Vacancy will not be a constraint for promotions. This is the promotion policy of yours. Vacancies will not
promotion policy may be there, my lord, but promotion policy, what was kept in abeyance, that is my case. Your lordship may kindly appreciate. It was kept in abeyance due to austerity measures. Because it was in a very bad financial state. Even now, my lord, we are struggling to pay salary. Your lordship.
28 ಜನ ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
ಅಲ್ಲ ಯಾರಿಗೆ?
28 ಜನರು ಕೊಟ್ಟಿದ್ರು.
ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರು ಯಾವ್ದು ವೇಗ ಹೇಳಿದ್ದಾರೆ, ಅವರು ಯಾವ್ದು ಕೊಟ್ಟಿಲ್ಲ. ಲಿಸ್ಟ್ ಕೊಡ್ಲಿ, ಅವರು ಲಿಸ್ಟ್ ಕೊಡ್ಲಿ, ಅವ್ರ ಡೇಟ್ಸ್ ಕೊಡ್ಲಿ, ಎಲ್ಲ ಕೊಡ್ಲಿ, ಸುಮ್ಮನೆ ವೇಗ ಹೇಳಿ. ದಟ್ ಈಸ್ ಮೈ ಕೇಸ್. You are not given any particulars. That is my case. Let him furnish the details. It is only his vague submission. Details ಕೊಡ್ಲಿ. I will check.
Saying it is not a promotion. Recruitment under an internal recruitment notification.
And after having taken one more submission, after having taken chance to apply against internal notification, after having appeared for a test and interview, and he cannot turn around and say that he should have been given under that promotion policy when it was kept in abeyance. ಅದು ಇವಾಗ ಸಂಬಳ ಕೊಡೋಕೆ ದುಡ್ಡಿಲ್ಲ ಅಲ್ಲಿ. ಇವಾಗ ಅಂತದ್ರಲ್ಲಿ ಯಾವಾಗ 2004 ಇಂದ ಪ್ರಮೋಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿರ್ತಾರೆ.
ಇವಾಗ ರಿಮೈಂಡ್ ಮಾಡ್ತೀನಿ, ನೀ ಕನ್ಸಿಡರ್ ಅಂತ ಇನ್ನೊಂದು 10 ವರ್ಷ ಓಡಾಡಿಸಿ ಸುಸ್ತಾ ಪಡ್ತಾರ ಅವ್ರೆ.
ಅಲ್ಲ, ಆ ತರ ಏನು ಬೇಡ.
12 ವರ್ಷ ಆಯ್ತಲ್ಲ ಇವಾಗ.
ಅಲ್ಲ ಬೇಡ. That is not my intention. That is not my intention. Your lordship may kindly appreciate. He retired in the year 2012. ಇವಾಗ ಇದು ನಾನು ಯಾರಿಗೂ ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಫೀಸರ್ ಗ್ರೇಡ್ಗೆ ಆ ಟೈಮಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ. ಪ್ರಮೋಷನ್ ಪಾಲಿಸಿ ಇದೆ, ಬಟ್ ಇಟ್ ವಾಸ್ ಕೆಪ್ಟ್ ಇನ್ ಅಬಿಯನ್ಸ್. It was uniformly kept in abeyance. I have not shown any discrimination.
Question ಕೊಟ್ರೆ ಎಷ್ಟು ಸಿಗುತ್ತೆ ಬೆನಿಫಿಟ್?
ಸೊ ಅದು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ಬೇಕು. ಸೊ ಹಳೆ ಕೇಸು
ಗೊತ್ತಾ ನಿಮ್ಗೆ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ?
ಇವಾಗ ಕನ್ಸಿಡರೇಷನ್ ಬರಕ್ ಆಗಲ್ಲ. ಇವಾಗ ಅವ್ರು ಕೇಳ್ತಾರೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ. ಇವಾಗ ನನಗೆ 11 ವರ್ಷ ರಿಟೈರ್ ಆಗಿ ಆದ್ಮೇಲೆ ಕನ್ಸಿಡರೇಷನ್ ಹೆಂಗ್ ಮಾಡೋಕ್ಕಾಗ?
The High Court is to blame because we kept the petition pending for 11 years. ಅಲ್ವಾ? ಮೋಸ್ಟ್ಲಿ ಪ್ರಮೋಷನ್ ಕೊಟ್ಟು ಮುಗಿಸಿ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಏನ್ ಹೇಳಿ?
ಮೋಸ್ಟ್ಲಿ ಪ್ರಮೋಷನ್ ಕೊಟ್ಟು ಮುಗಿಸ್ಬಿಡಿ ಅಷ್ಟೇ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಕಷ್ಟ ಆಗುತ್ತೆ. ತಮಗ್ ಗೊತ್ತಿಲ್ಲದೆ ಇರೋದೇನಿಲ್ಲ HMT ಬಗ್ಗೆ, ನಾನೇನ್ ಜಾಸ್ತಿ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ.
ಅದೇನೋ ಸಿಮಿಲರ್
ಕೊಡಕ್ಕೆ
ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಕ್ವಾಶ್ ಆಗಿದೆಯಂತೆ.
ಯಾವ್ದು?
ಪ್ರಮೋಷನ್
ಕೊಡ್ಲಿ, ಲಿಸ್ಟ್ ಕೊಡ್ಲಿ, ಸುಮ್ನೆ ಹೇಳೋದ್ ಬೇಡ. ಅವರು ಕೊಡ್ಲಿ, ಲಿಸ್ಟ್ ಎಲ್ಲ ಕೊಡ್ಲಿ. ಅಲ್ಟಿಮೇಟ್ಲಿ ವಾಟ್ ಎವರ್ ದ ಡಿಸಿಷನ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ರೆಂಡರ್ಸ್, ದಟ್ ಬೈಂಡ್ಸ್ ಮೀ. ಅದು ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಯಾರ್ಯಾರು ಕೊಟ್ಟಿದ್ದೀನಿ, ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವ್ದು ಕ್ವಾಶ್ ಆಗಿದೆ ಅಂತ ಅವ್ರು ಲಿಸ್ಟ್ ಕೊಡ್ಲಿ. Because this has got long repercussion, my lord. I have stated my position very clear. But ಅವರು ಎಲ್ಲ ವೇಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರ ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ವಿ, ಈ ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ವಿ.
ಯಾವ್ದು ನೋಡಿ, WP 24569/2009 ನೀವ್ ಹ್ಯಾಪಿ ಆಗಿರೋ ಇದ್ರಲ್ಲಿ. The order keeping the promotions abeyance was quashed, and the direction was given to promote from wage grade to pay scale cadre. WP 24569/2009 HMT there. Joshua Samuel appeared on behalf of HMT there.
Notice, I am not aware of this.
I will only say apply the promotion policy and grant my promotion.
ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ.
Because in this case it is held that this promotion policy was an outcome of a bipartite settlement, and you have to give effect to that settlement. You cannot push it onto the carpet.
Having regard to the present status, my lord, after retirement, after 11 years after retirement, it is for your lordship's consideration whether that such direction
ಎಷ್ಟು ಬರುತ್ತೆ ಕಾಸು ಅಂತ ಕೇಳಿದೆ. ಮೊದಲೆಲ್ಲ ಒಂದು ಕಾಜಿನ್ಯಾಯ ಮಾಡ್ಕೊಡ್ಸ್ಬಿಡಿ ನೀವು, I'll ask him to withdraw ಅಂತ.
So I will take instruction, my lord, please. I will take instruction.
ಅಮೌಂಟ್ ಕೇಳಿ ಕಿತ್ತಾಡಂತದ ಇಲ್ವಾ ಅಂತ.
I will take instruction. ಒಂದು 2 weeks ಕೊಡಿ ಟೈಮ್. ಸ್ವಲ್ಪ
2011 ನಾನು ಇವತ್ತು ಮುಗಿಸ್ತಾ
ಸ್ವಲ್ಪ ಅದು ಹಳೆ ಇದೆಲ್ಲ ತಿಳಿಸ್ಬಿಟ್ಟು ನೋಡಿ.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ
ಲೆಟ್ ಮಿ ಅಸಿಸ್ಟ್ ದ ಕೋರ್ಟ್. ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಬೇಡ, ವೆನ್ಸ್ಡೇ ಕೊಟ್ಬಿಡಿ ಸರ್. ನೋಡಿ, ವೆನ್ಸ್ಡೇ
ಆಯ್ತು. What is the next year, G? ಒಂದೇ ಒಂದು LTC ಒಂದೇ ಅಲ್ವಾ? ಬರೀ LTC ಒಂದೇ, LTA ಒಂದೇ ಕೇಳಿದ್ರು ಅಂತ. ನಮ್ಮ ಖಾತೆ ಮಾಡಿದ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 7 and 9 ಅಷ್ಟೇ ಕೇಳ್ತಿರೋದು ನಾನು. 7 and 9 ಬರ್ಕೊಂಡು ನಾಯಕರೇ ಕೊಡಕ್ಕಾಗುತ್ತಾ 9 and 12? Naikre. ಇದನ್ನು ಅಲ್ಲೇ ಕಳಿಸ್ಬಿಡ್ಲ ಕಂಪನಿ ಕೋರ್ಟ್ಗೆ. ನಾಯ್ಕ್ರೆ next year why page number where is the charge sheet? Where is the charge sheet? Actually, Amma. The transfer certificate that they procured indicated to belong to scheduled caste.
Very deputy. They are saying that this was inquiry held to the site itself. Now they have come to this conclusion that the petitioner is an Reliance PhD. Then inquiry was closed.
Where was the inquiry closed?
This was written by the Deputy Commissioner for the petitioner of the World System.
Was granted an appointment only on the basis that it belongs to scheduled tribe, isn't it? It was granted an appointment only on the basis that it belongs to scheduled tribe. And you sought for genuineness of that particular certificate. It is held to be genuine.
2011, 7 it was reviewed as well. Year 2021. See that the prayer would be very distant. If the act was not, there is a discussion about it. Then the rest of the words, they refer to the
Yes. Yes, Mr. Ravi. Charge that you had made against him was next year ML, va? Page 55 is the charge sheet, isn't it? Article of charge. That it submitted a tempered transfer certificate. What was the certificate that he produced? He had produced a certificate to that effect. Number? Yes.
There was no response. I am not informed of the matter.
From 2005 to 2011, you kept quiet. 87 appointment, 2005 you seek for genuineness, then you wait for 6 years. Would you be heard in the matter? Then the concerned authorities have issued a certificate saying he belongs to scheduled tribe. It's confirmed by the deputy commissioner who issued the certificate. You have not challenged it, isn't it? We challenge that. Forget about this. The other certificate that the deputy commissioner reported. That is at annexure AC, page 151. No, 2006, they gave you this letter. Once they give this letter to you, whether you challenge it or not, you are not an adversary litigation with them. He only wanted genuineness of his caste certificate. He had given you a certificate saying he belongs to scheduled tribe. The authority which issued that certificate, the competent authority, reiterates that the certificate given is genuine. So you still want to go beyond them, and until you get a certificate of your choice, you will not accept. Procedure is only to ask for genuineness from the concerned authority. When did the act come into force? So obviously, how can you apply these rules to recruitment that you made in the year 85? Where was it pending? No, you should get me over this problem. 85, 86, you recruit him. You ask for genuineness in accordance with the direction of the central government. The concerned authority says it is genuine. Matter should end there. It is not for. The act can't be applied because the act is of the year what? I'm not prepared to accept this argument that whenever you get up, whenever you wake up, everybody should jump to your. He told you belong to scheduled tribe. He gave you a certificate which said you belong to scheduled tribe. You now want to take advantage of a discrepancy in the TC. I'm only concerned with your charge. Your charges. How could you have issued this charge sheet in the light of this particular endorsement that you got?
Admission there. Oh, that's
Page number? Page number? 35. The job was reserved for a scheduled tribe. Scheduled tribe. He made an application on the ground that he belonged to scheduled tribe. He gave a caste certificate which said he was scheduled tribe. You doubted this. That is what you sought for, genuineness. You sought for verification of that. No, the caste certificate that he produced. Please come to page 151 again. This is a letter dated 22/9/2005 that you wrote. That is at page number 147. Now forget about the transfer for a minute. Let us see. Annexure A. Annexure A. The time of joining service. Correct. Okay. Read it completely. ಪೂರ್ತಿ ಓದಿ. Last paragraph. So this is what you said. You are doubtful because there's a discrepancy in the transfer certificate and the caste certificate. You wanted authentication as to whether he belongs to scheduled tribe or not. You addressed this letter to the Deputy Commissioner of Bangalore Urban District. Now his reply is at page 151. So you can sit in judgment over that and say, you are doing that now, you are not disregarding. Despite that, you asked for authentication. They authenticated this document to you. Notwithstanding this, you proceed to give a complaint to the CRE. That report is given, you are agreed by that report. Now, notwithstanding all this, you have issued a charge sheet against him, saying that there's tampering. What is the tampering? Is that your only concern, Mr. Senior Counsel, was that whether he belongs scheduled tribe or not. If you had secured an employment, not being a scheduled tribe, you had a grouse. You had a right to terminate him. If the authorities, concerned authorities, find that he did belong to scheduled tribe, matter should rest quite there.
So 98 years, 1985, as a certificate, this without. How can you show me bigger? There were not 10 meetings, so I expected everyone.
What is the tampered certificate that he produced? What did it say? In the original of the, in the certificate that he produced, what did it indicate? Same school or different school? Where is that? Where is that document? Both the documents, the one that he furnished and the one that you secured. Even then, this is of no relevance because he does belong to the scheduled tribe. H. Your objections. This was given to you by whom? Yes. And where is the certificate that he produced? One. But you did not give the employment on the basis of this certificate. You gave the employment on the basis of the caste certificate. He produced a caste certificate. He did not give you a caste certificate. Where is his application? There is no, he did not suppress the fact that he belonged to some other community and did not represent that he belongs to scheduled tribe. He did indicate he belonged to scheduled tribe. He was backed by a certificate. You somehow want to catch hold of him After how many years? I will hold your conduct of keeping quiet from 2005 to 2011. So you can do whatever you want to do. You're going to catch hold of an employee at the fag end of his career and harass him. Then what? From 2005 till 2011, despite getting a certificate, you are victimizing him. So therefore, until you get a endorsement of your choice, you're not going to stop harassing him. Your only job was, as per the director of the central government, I want to appreciate your conduct. You're the model employer. I'll come to him afterwards. You're the model employer. That indicates some kind of victimization. I don't know. That's why I'm worried that an organization like yours is going after one person like this. It's not like as if he's a top scientist and is getting some huge favor. He's some ಅವ್ರಿಗೆ ಸುಮ್ನೆ ಅವ್ರಿಗೆ ನೀವು ಗಿಫ್ಟ್ ಕೊಡ್ತಾ ಇದ್ರ. I may also agree with you, but that's a different point. ಅದನ್ನ ಮಾಡಿ ಚಾರ್ಜ್ ಮಾಡಿ ಅದಕ್ಕೆ ಬಿಸಾಕಿ ಇದನ್ನ ಯಾಕೆ ಇದನ್ನ What do you propose? No, I leave it to you. You don't want him, fine. I am concerned that I have to reinstate him with full back wages. You're giving this kind of a person bounty for committing a fraud. You're as guilty as he is in this matter. You reinstate him, no back wages, let him work for 1 year and then get rid of him. As it is, that is the best punishment possible. If he's entitled for some benefits, let him get some benefit and walk out. He'll work for what, 6 months or 7 months. Illa nanu, I'll have to set aside this order, then order back wages and all benefits, one more writ appeal, SLP. Tomorrow. Reinstatement, no back wages. ಇಲ್ಲ ಅವ್ರ ಏನಾದ್ರು ಕಾಸು ಕೊಡ್ತಾರ ಕೇಳಿ ಕಾಸು ಇಸ್ಕೊಂಡು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು that time against you could not, you definitely victimized. ಆಮೇಲೆ ಏನೋ ಕಣ್ಣಿಟ್ಟೆ ಇದನ್ನ ಆಗಿರೋದು ಸುಮ್ಮನೆ ಇಷ್ಟು ಇಂಟ್ರೆಸ್ಟ್ ತೋರಿಸ್ಬೇಕು ಎಂಪ್ಲಾಯರ್ ಅಂದ್ರೆ ಗ್ಯಾರಂಟಿ ಏನೋ ಇದೆ ಅದ್ರ ಏನೋ ಕಾಸು ಕೊಟ್ಟು ಕಳಿಸ್ಬಿಡಿ ಅವ್ರನ್ನ. If it's permissible, the board can take a decision, get rid of him tomorrow. In matter in butter. Is the order next year J na? Next year J. Page. ICSE ಸ್ಕೂಲ್ ಅಲ್ವಾ ಇದು? ICSE ಸ್ಕೂಲ್ ಇದು? Send it back. ಅಪೀಲ್ ಏನ್ ಹಾಕಿಲ್ವಾ ಇವ್ರ ಮೇಲೆ? ಅಪೀಲ್ ಏನ್ ಹಾಕಿಲ್ವಾ? ಲೆಕ್ಚರ್ ಇಲ್ವೇ ಇಲ್ವಲ್ಲ? Additional objections. ಏನಾಗಿದೆ? Yeah, what is this 2017 amendment? What is the amendment of the year 2017? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನಾಗಿದೆ? What has happened under the 2017 amendment? Where is the amendment? Amendment to section? It talks about regulation of education. Or by virtue of this amendment, automatically now it will be applicable, isn't it? That will apply in its entirety, isn't it? No, but subject. No, that will continue to apply. First one, education institutions affiliated. Subsection 3 says it applies to all educational institutions and tutorial except. This you have said, this you say has been struck down. Good year. Tomorrow. I don't need him for this. Go through it tomorrow. Give it to him today. Tomorrow. It's a question of law. If it is been upheld, the matter ends there. Tomorrow. 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 What he says is correct. Then there's no need for an argument. ನಾನು ನೋಡ್ತೀನಿ ನಾಳೆ ನಿಮ್ ಜೊತೆನೆ ನಾಳೆ ಬರ್ಲಿ ನಾಳೆ next year F and G. Next year F and G, huh? Page number. Page number. What was the charge against you? Where is the order of punishment? First order, annexure. F. Yes. Both of you took this appointment on account that you belong to the land users category. And the policy only permitted one person per family. Use what? ಏನ್ ಹೇಳ್ತೀರಿ? Page number? Page 21.
A cross misconduct in as much as
Page 21. Page 21 ತಾನೆ? Statement of articles of charges.
in as much as he gave an employment in Konkal Railway Company under Srag Mr. Category for having crossed the line survey number 79 R2B, area 27 acres of the employment in Konkal Railway Company. Ministry of Road. By doing so, he fills the fact as his elder brother to the Ishwar also secured a job in Konkal Railway Company. Part 9, area 053 acres.
Your brother said answer number 66 bar 9 had been lost. You said number 79-2B.
The 79-2B belongs to the petitioner here. This the 66 bar 9 is the family problem. There is a family party system.
When did you acquire this 79-2B?
The entire officials, they have not connected a proper inquiry as per the finding. According to my, what is the errors in holding the department of the employment of the aircraft? The error is you know, it output have for any crime there.
ಅವ್ರ ಕೆಲಸನ ಹೋಗ್ಬೇಕು ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇರೋದು? ಇಲ್ಲ, ಅವ್ರ ಕೆಲಸನ ಕಿತ್ತಾಕ್ಬೇಕಿತ್ತು, ನಿಮ್ ಕೆಲಸನ ಕಿತ್ತಾಕ್ಬೇಕಿತ್ತು. ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ರೆ ಇಬ್ರು ಹೋಗುತ್ತೆ. And he is not challenged. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ ಸುಮ್ಮನೆ. Both of you belong to the same family. You admit that your brothers. Okay, if you can show that this particular property 79/2B was your self-acquired property, then you may have a better case. ಅದರಲ್ಲಿ ಯಾವ ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? We issuer claimed surrender number 66/9, family property. ಇದರಲ್ಲಿ Gopal and Krishna. Chandran bar 2P was standing in whose name?
The name of the Krishna.
Who's Krishna here? ಯಾರು ಅವರು?
Author of the
How will it be self-acquired property?
Serial number 4. Serial number 4.
Gopal.
Land user. The new part. There are 5 owners there.
Gopal Sharekar, Krishna Sharekar. ಸರ್ವೆ ನಂಬರ್ ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ? ಸರ್ವೆ ನಂಬರ್ ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ? ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಫಸ್ಟ್ ಒನ್ ಈಶ್ವರ್ ಅಲ್ಲಿ.
Total area before acquisition 23. Out of 23, 3 years. That's been noted. And this so far the other petitioner is concerned. And equal petitioner.
Yes.
That is Ravindra. The column number 4.
Therefore, both the properties were belong to your father only.
That is the name has been included in the joint family.
No. In the application that you had submitted, even in Ishwar's case, the property is shown to belonging to Krishna Pasharekar, Venkatramana, Parma somebody, and Gopal. So it was not standing in your name, not in the name of Ishwar. Ishwar's father name is Krishnapana, and even in respect of Ravindra. So even there he says the land belongs to his father. To self.
Father name is alone, occupied property. Then my lord, I have to reach a partition here out. Which has before the advice.
Registered ilva? Registered alla.
Yeah. That is dated 1/2/1990. Second paragraph.
ಕುಮಾರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟರ್ ಆಗಿತ್ತಾ? ಯಾವಾಗ ಆಗಿತ್ತು? ಜ್ಯುಡಿಷಿಯಲ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟರ್ ಆಗಿತ್ತ?
We have reduced the amount that they have taken into consideration of this party setting. They are entitled in a single court. You are not go with the
Yes.
The corporation
Where is this first notification of 96? Oh, the first one. This is 98, isn't it? No, no. Where is the condition that only one person per family? This is at 1696. This is the first notification. No. No. This July 1996 notification was exclusively meant for recruitment amongst the land users. Where is that notification? Where is said only one job per family? Yes. They applied under this notification. So at least you can keep one of the jobs. How can you throw out both? All right, but one. No, let's assume that they have been fraudulent. Give one job at least. Whoever made the first application, give it to him. Second application goes. It's not like you're giving it for a land loser. The advantage that they've taken, they will lose. But why should you take away that? So you're not denying the opportunity to the family despite your policy. You punish the other person, I'll agree, I'll go with you. But what about that one job that they're entitled to? Is there any such condition saying that if two people apply, everybody lose their job? Then keep one job to them and throw out the other person. Whoever came first, keep him, throw out the other guy. Yaar first application ಆಗ್ತಾರ ಅವ್ರದ್ದು. ಏನಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ರ? ಯಾರು ಫಸ್ಟ್ ಆಗಿ ಅಪ್ಲೈ ಮಾಡಿರ್ತಾರೋ, ಯಾರು ಫಸ್ಟ್ ಕೊಟ್ಟಿರ್ತಾರೋ But how could you throw them both out? You should also have been careful. ಯಾರೋ ಒಬ್ರಿಗೆ ನೋಡಿ, ನೀವು ಇಬ್ರಿಗೂ ನೀವೇ ವಕಾಲತ್ ಆಗ್ತೀರಾ, ಯಾರು ಬೇಕು ಅಂತ ಫಸ್ಟ್ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ. tomorrow.
Serial number 54, I am appearing for the petitioner, my lord.
Yes.
Lord, your lordship may kindly take WP 56440 of 2014, my lord, connected petition. Lord, the impugned endorsement is at page 38, my lord. Lord, the petitioner was working as a senior public relation officer. Lord, he was denied the benefit of revision of pay band, my lord, 37,467,000 with effect from 1/1/2006. Lordship may kindly see the last paragraph, my lord. The revision of pension in PB4, that is 37,467,000 with GP 8,700 for pre-2006 non-teaching post cadres are made applicable only in respect of those who hold designations of Deputy Registrar, Deputy Finance Controller, and Deputy Controller of Examination subject to completion of 5 years in the pre-revised scale of 3,700, 5,700 as applicable prior to 1/1/96 and rupees 12,000 and 18,300 as applicable prior to 1/1/2006 as provided under MHRD letter dated so and so. He's been denied only on the ground, my lord. He was working as a senior public relation officer, which is an isolated post.
But what is the pay scale? What is the pay scale that he was drawing?
He was in the scale of 3,700, 5,700, much prior to 1996. Your lordship will get at page 15.
Page
15. Lord, he was extended the benefit of 3,700, 5,700 on 1988 itself. In the middle, my lord, your lordship will get it. And he retired on 31/7/95. Therefore, my lord, 5 years prior to 1/1/2006, he was in the scale of 3,700, 5,700 from 1988. Now, my lord,
as on 2006, what was your pay scale?
My lord, I would be in the same scale. That is 12,000 and 18,300. That is the revised scale.
Yes.
So, your lordship, for a moment, my lord, lordship, what they did is that during the pendency of this writ petition, my lord, the benefit is being extended, my lord, by a resolution which I have produced along with the IF for production of additional document. Your lordship may kindly see.
Yes.
Annexure P, my lord, page 4, my lord. This is a resolution passed 17.4, my lord. Note on placement of Group A officers in PB4 with grade pay of 8,700. The council revised a note on extending the benefit of placement in PB4 to the Group A officers in isolated posts. Lord, treating my post as an isolated post, my lord, they are sought to extend it from 17/3/2018, though I was entitled from 1/1/2006. And whereas, my lord, your lordship may kindly come to page
2018 ಅಂತ ಎಲ್ಲಿ ಬರ್ತಿದಾರೆ?
ಮೇಲ್ಗಡೆ ರೆಸಲ್ಯೂಷನ್ ಸ್ವಾಮಿ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ಲಿ ಅಂತ.
ಎಲ್ಲಿ?
This they sought to extend it and they called him and then they said that they will extend it from 17/3/2018 prospectively in case you withdraw this writ petition. Now, your lordship may kindly see, similarly placed persons have already been extended from by a resolution, my lord, at page 32.
Credit
of the petition. This is a resolution dated 25/3/2009, my lord. I am reading it 10.5.15, my lord, resolution number Roman number 4, my lord. 10.5.15, my lord.
Yes.
Now, resolution 4 that the revised pay structure of pay band and grade pay corresponding to pay revised scales of pay in which the employees were drawing pay as on 1/1/2006 will be extended to non-teaching group A, B, C, D employees of the institution while implementing the 6 pay recommendations approved by the government. Having extended to all group A, B, C, D, my lord, they could not have treated my claim only as an isolated post and denied me. Further, my lord, next page, my lord, one more resolution was passed, my lord. Page 33, Annexure G, 8.4 paragraph, my lord. The director informed the member of the cadre of technical officers was unique to the institute and MHRD circular dated related to the implementation of 6 pay recommendations do not mention this. At the institute, this cadre has been treated on par with all other cadres in the administration non-teaching category since the equivalent posts in the administration have been given the similar benefit. Technical officer grade 3 were also be given the benefit placement of PB4 37,400 67,000 with GP of 8,700 after 5 years of technical officers in PB3. The council ratified the action.
Where is this MHRD letter dated 15/12/2009?
No, that is at page 27, my lord.
27.
Yes, ma'am. The lordship may kindly come to page 28, last paragraph 3, my lord.
One minute. So it only says corresponding scale, is it not? This annexure D. It does not specify any post. It simply says shall mean that pension of all pensioners irrespective of the date of retirement shall not be less than 50% of the minimum of the corresponding scale as on 1/1/1996 of the scale of pay held by the pensioner at the time of superannuation retirement. So whatever was the pay scale that was being drawn on 1/1/96 is what is relevant, not the post. So if that particular pay scale post yes. Who appears in this matter? Error? HR, Kodabidri Mohan for R2 and R. Allan Gaud. R2. You appear for the same institute? I deal with it, but this what is the argument? No, the clarification is clear. The clarification. No, it is on the basis of this clarification the claim is rejected. This is the order. This is the order. No, the office order that is challenged talks about the revision of pension in pay band 4 for pre-2006 non-teaching cadres are made applicable only in respect of those who hold the designation of deputy registrar / deputy financial controllers / deputy control of examinations, subject to completion of 5 years of service in the pre-revised scale of rupees 3,700 to 5,700 as applicable prior to 1/1/1996 and rupees 12,000 to 18,300 as applicable prior to 1/1/2006 as provided under MHRD letter number so dated 15/12/2009. There is no designation. There is no designation wise classification.
And this designation is not available in 15/12/2009 government order, my lord.
Oh, is it open for the institute to take that kind of a stand in the light of a clarification? You can have your own pay scale. You can disregard who's funding all this, who's paying the salary. So then the entire salary is paid by the union only. So you can reduce the pay also. This is a question of extension of pay scale. So where is this? What is the purpose of this? Then you're basically defeating the Fifth Pay Commission by adopting this kind of ambivalent stand. You can take a stand whenever you want. You can. Is there any decision in relation to the application of the Fifth Central Pay Commission which says you can dig your own? I'm talking about, is there a decision of Supreme Court which is, if it's a question of extending Fifth Pay Commission's recommendations, that will have to be uniform. You cannot therefore to pick and choose amongst your employees as to who will get Fifth Pay Commission or who will not get Fifth Pay Commission. Maybe I will concede to the fact that the clarification issued by the central government is no. That is again based on this 11 May 2001. You rely upon the same 11th May 2001 clarification. 2001. Next year D.
Page 26.
And I would have to get instructions on this also. He is not agreeing. Produce that letter then.
Not they are only, the petitioner is 89 years old, my lord. And he's been fighting for this, my lord, since 2011. He is before this honorable court. Now, my lord, they are threatening him to take this, whatever they are giving. Otherwise, they'll proceed with the appeal and other things they are threatening, my lord.
He's asking you a question. What is your answer?
The institute has evaluated the honorable court. Thus, I don't know why my consideration, my explanation would not.
What that is ways before this court also. Why are you not answering this question? No. Our answer is, sir, my question now is, am I eligible for PB4 scale pension with effect from 1/11/2008? In case I withdraw case number so and so.
If there is a resolution, I cannot go behind it. There is a resolution. That is possible. We calculate areas of
That is the whole point of this pay commission benefits. If you are going to deny him that, what is to all employees who are drawing a particular pay scale, they will be eligible. So you are going to decide whether to apply the fifth pay commission or not. So that is on facts, but on principle, if fifth pay commission is to be extended, it should be extended to all employees. It's not a question of you. In case of pensioners, it's not a question of adopting. It is a mandate. 50% of the pension for those people drawing this particular pay scale as on 1/1/2006. That's it. Even though you are not paying it from your pocket, the central government is going to pay it. Then why are you fighting for it? I'll decide this first. If nobody comes day after tomorrow, if you get instructions, okay. If nobody comes, I'm going to allow the writ petition and hold that is eligible. Inform and take up your matter afterwards, after that day. You are the Indians of science. If you can't communicate them via email and get a reply, Now just tell them that I'm going to pass. Not, he's 82 years old is what he's saying.
89, my lord.
Depending for how many years now. arrived on Thursday. Thursday. No, Thursday. Since you are here, at least I have somebody to catch. Thursday. The third instruction, you have the same instruction. If you want, I'll direct you to take notice because nobody appeared on behalf of the institute. You want me to do that? Thursday. Yep. What case respondent? The Mysore Minerals are up there. In madam. What is the reason for excluding Group A and Group B? Yeah, but the company itself said it is making a profit and they can play. I'll come to page number 5 of your objections. From the middle, the board of the first respondent in its meeting held on 13/3/2013 has resolved to send a proposal to the state government and accordingly forward a letter dated 25/3/2013 stating that the first respondent has been recording profit since 2003-4 and has got sufficient surplus funds towards payment of arrears as per the fourth pay recommendation. They are saying that they have the money. You are saying no, I don't give it to them. Yes. No, but they are themselves saying that we have money to pay, but you are excluding. ಇಲ್ಲ ಅವ್ರ ಕಾಸು ಕೊಡೋರೆ ಕಾಸು ಕೊಡ್ತೀನಿ ನೀವೇನ ಬೇಡ ಅಂತಿದ್ರ. Come to para 7. Para 7 ನೋಡಿ. Of your objections. There must be some reason to excluding group A and group B. Why are you penalizing them? Yes. Next is UVW, na? Next is UV and W. All of them. All of them.
And the petitioners, the expedition number 4 are the ones who are not. The dispute is only with respect to the persons who are not writing the.
No, the petitioners in the first two writs are all working now.
No.
Without salary you're working. What is annexure U? Yeah, ನಾನು ಫಸ್ಟ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಾ? What is annexure U here? As per annexure U, their service was to come to an end on 31st March 2016. But you have continued them from 2016. So therefore, you are continuing them either in this organization or some other organization. Then
what has happened? There the petitioners are, and the federal government said they do not do that. So what we did was, we said the team is getting slow because of the government direction. So we are closing this floor. And then the honorable court gave the interim order and they are fighting. And then during the pendency of the recruitment, we passed the order emergency. There is a scheme under state government which the vacancies were errors. Because the two category of people are one is the technician, other one is the councillors. Those two category of others, the employees also were needed in state run program. Then as is when instead of appointing the contract employee, we went on in appointing these people. The very pre-employment order was changed by the petitioner telling that we are not doing anything in a place where vacancy is available. Because in the place where the petitioners are working, Those centers are closed as per the central government directions. In fact, all those making sectors before have stated so in my academic notes. And because the petitioners are not working, now even after reshowing them the field and giving them estimates that interest on vacancy alone here, we are going to comfort them back. They refuse to come and work. And the centers which they are running, that they are working, they are closed long matters. And the certificate, what they are showing, produced before this honorable court, saying that they are the employees that doesn't like telling that they were, because they were work, yes, the appointment order is for DPP. And they have produced the certificate, but it's only
There were 128 petitioners, and several of them are withdrawn the writ petition.
they are all working with our agency.
Even now,
Even now.
those people are withdrawn,
Yes, sir. Their salaries fully paid.
and others who are not withdrawn.
They are-
Can you file a statement as to who are the?
Even my husband, twice he took this order. Even if I am dealing with
Where is the affidavit?
long that twice I am.
WP 28177 ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ 4094.
ಇದ್ರಲ್ಲಿ ಬೇಡ ಬೇಕಾಗಲ್ವಾ?
ಅದರಲ್ಲಿ ಇದಕ್ಕೆ
ಇಲ್ಲ, ಇದರಲ್ಲಿ ನನ್ಗಿರೋ ಕಾಸ್ಟ್ ನಲ್ಲಿ ಬರ್ಕೊಂಬಿಡಿ. ಪಿಟಿಷನ್ ನಂಬರ್ 6, 11, 14, 33, 34, 46, 53, 81, 83, 89, 96, 104, 106, 108, 110, 114, 118, 119. Then 120, 122, 123, 124. These are the only petitions pending. All others have withdrawn. Now these people, according to you, are still working, and she is not accepting that. Where is the certificate that you produced now? Or ಕೊಟ್ಟಿದ್ದೀರಾ?
certificate number now. Document.
No, I gave you the numbers. File an affidavit as to whether these other people who not withdrawn the writ petition are still working, not working, or if they're working, where they're working. First ಹೇಳಿ ಆಮೇಲೆ let us check. ನೀವು ಯಾರಿಗೆ ಮೇಡಮ್? The counsel for the fifth respondent is directed to file an affidavit narrating details about those of the petitioners who are being deployed in different organizations and who are still continuing in services. The fifth respondent will also state the petitioners who have not been deployed or who have shown disinclination to continue. The affidavit we filed on or before. 28182. That I'm only concerned with 28182 now. ನಾವು ಒಪ್ಕೊಳ್ತಿಲ್ವ ನನಗೆ ನಿಮ್ಮ ಮಾತು ನೀವು ಹೇಳಿದ್ರೆ if you were to say that this does not survive, will say it does not survive. Whenever you want. Investor. He is in no hurry, I am in no hurry. 2016 matter. Let come out 3 weeks. 2 weeks, 700. 2 weeks. Yes. Session of not clear, la? You are placed to challenging annexure AA. Where is annexure AA? Against pension is refused on the ground that you have got promotions and therefore you're ineligible. Ullekha 4 is this government order 18/7/2018. Page. That is at 2018 order. Huh? Seven zero. $77 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತಲ್ವಾ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ. ಎಸ್. ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ ಪ್ಯಾರಾಗ್ರಾಫ್ 2? ಉಳಿದ ನೌಕರರು You were a part of this soaps and detergents earlier. Now you were absorbed pursuant to this government order. You will not challenge this government order. No. But you accepted this order of the government for being absorbed as a government employee. No, this government order that you referred to at page 175, 178. Next challenge ಮಾಡಿದಿರಾ? You're challenging only annexure AA. Annexure A is based on this annexure H. But if you don't challenge annexure H, then what is the point? Your claim was rejected only on the basis of this annexure H. ಇಲ್ಲ prayer ನೋಡಿ. Prayer. Please read page 178. Read from page 177. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಬಗ್ಗೆ. Hello. You were one of the petitioners in this WP 48089 dash. All of you are petitioners in that. ಉಳಿದ ನೌಕರರು. All of you are persons who are petitioners in this petition. Where is that order? Is that a fact copies for the soaps and detergents? Is it a fact that all of them are parties in that writ petition? No, the government order is in their favor, isn't it? If you read the first paragraph. ಅದೇ ರೀತಿ ಈ ಪ್ರಕರಣದಲ್ಲಿಯೂ ಸಹ ರಿಟ್ ಅರ್ಜಿ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಕರಣಗಳ ನ್ಯಾಯಾಲಯದ ಮೊರೆ ಹೋಗಿರುವ ನಿವೃತ್ತ ವ್ಯಕ್ತಿಗೆ ಈ ಸೌಲಭ್ಯ ವಿಸ್ತರಿಸಲು ಸರ್ಕಾರವು ಆದೇಶಿಸಿದೆ. Correct, but this is in respect of those people who did not go to court. The first portion is in respect of people who had gone to the court, for whom you would have granted pension as ordered in this writ petition, in consonance in parliamentary with Sericulture Corporation. ಉಳಿದ ನೌಕರರು, those who had not gone, for them they impose this condition. No, that is in respect of those people who have not gone to the court. The first paragraph of this 87/2018 talks about restricting the benefit only to those petitioners who were parties in WP 48089-48247. That you cannot deny. The second portion, ಉಳಿದ ನೌಕರರು, how can you impose this condition to them? ಎಲ್ಲಿ? ಅಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ? ಎಲ್ಲಿರೋದು? This is in respect of first sentence. ಉಳಿದ ನೌಕರರು ಸಂಸ್ಥೆಯಲ್ಲಿ ವಿಲೀನಗೊಳ್ಳಲು ಅಥವಾ ನೌಕರರೆಂದೇ ಮುಂದುವರಿಯಲು ಅಭಿಮತವನ್ನು ನೀಡಲು 6 ತಿಂಗಳ ಕಾಲಾವಕಾಶ ನೀಡಿ, ಅವರು ಒಂದು ವೇಳೆ ಸಂಸ್ಥೆಯಲ್ಲಿ ವಿಲೀನಗೊಳ್ಳಲು ಇಚ್ಛೆ ವ್ಯಕ್ತಪಡಿಸಿದ್ದಲ್ಲಿ ಅವರನ್ನು ಅರ್ಹತಾನುಸಾರ ವಿಲೀನಗೊಳಿಸುವಲ್ಲಿ ಹಾಗೂ ಸರ್ಕಾರಿ ನೌಕರರೆಂದು ಮುಂದುವರಿಯಲು ಇಚ್ಛಿಸುವ ನೌಕರನ್ನು ನಿಯೋಜನೆ ಮೇಲಿರುವ ನೌಕರರೆಂದು ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ. ನಿಯೋಜನೆಯ ಮೇಲೆ ಮುಂದುವರೆದ ಸರ್ಕಾರಿ ನೌಕರರೆಂದು ಪರಿಗಣಿಸಿದಾಗ ಪಿಂಚಣಿ ಸೌಲಭ್ಯಗಳನ್ನು ಪಡೆಯಲು ಅರ್ಹರಾಗುವ ನೌಕರರು ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳ ನಿಬಂಧನೆಗಳನ್ನು ಪೂರೈಸಲು ಒಪ್ಪಿದೆ. So those who give option to become an employee of the government, they will be subject to these conditions. But in respect of those people who have already gone to the court and got this order, you will extend the benefit of pension. Wait, please wait. ನಂಗೆ ಒಂದೇ ದಿನ ಮುಗಿಸ್ಬೇಕು, ಒಂದಿನ 1 ಪಾಯಿಂಟ್, ನಾಳೆ ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ಕೇಳ್ತೀನಿ, ಇನ್ನೊಂದು ಡೇಟ್. ವೀಕ್ ಎಲ್ಲ ಇಲ್ಲ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ನೀವೆಲ್ಲ ಯಾರಿಗೆ? ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ತಗೊಂಡ್ರು ರಾಜಗೋಪಾಲ್ ಏನೋ
Serial number 71, my lord.
ನಿಮಿಷ. Speed next week. ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋರಿಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊ.
My lord. My lord. My lord. My lord.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಹಾಕೊಳ್ತೀನಿ.
My lord.
ಈಗ ಎಲ್ಲ ಜಾಸ್ತಿ ಆಗೋಗಿದೆ ವಾರ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ತೀನಿ.
My lord. My lord, serial number 71.
ನಿಮಿಷ ಬರ್ತೀನಿ.
71, my lord. Petitioner is the cancer patient, my lord, bedded and covered by the judgment, my lord.
ಕೊಡ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ. ನೀವು ಯಾರಿಗೆ? ಎಂಪ್ಲಾಯಿಗೆ ಮಂಡೇ ಮುಗಿಸ್ಬೇಕು. Next Monday I'll take.
Serial number 71, my lord.
Next Monday. Okay, number code.
Serial number 71, my lord. Petition is the cancer patient and bedridden, my lord, covered by the judgment. ದಯವಿಟ್ಟು ಬುಧವಾರ ತಗಲಿ ಸಮಯದಲ್ಲಿ 2 minutes. ಮಚ್
71
71, sir. 71.
8.